You use the mic.
Lordship, the alleged offense is under section 302, but charge sheet is under section 306, Lordship. The petitioner is the brother-in-law of the
No,
deceased,
bail.
Lordship.
Bail, fresh bail.
Tied up matter, but
No, tied up no.
Then why are you mentioning here?
Lordship, this assignment of this
No.
before matter, sir.
24 there.
up to March.
No, you have already filed.
Lordship.
Before March, you have filed. Oh, it will come. All the matters, serially it is coming. No problem. Yes.
I beg pardon, my lord.
Yes.
Weekly list item.
Pardon me, my lord.
Kindly be
I
taken.
don't know whether we can reach weekly list or not.
No, because he is counting his days due to corona.
Huh?
I request for take up.
When it was supposed to be taken up, nobody was there. Now, I don't know. I don't know whether it can be taken up. Wait, after till 2 o'clock, let us see whether how the board moves.
Pardon me, my lord. Pardon me, my lord.
Yes.
Yes, sir. There is a item number 27. There is a bail
Yes.
matter that become, because the case is ended in acquittal, my lord. That has become infructuous.
Oh, it's a good news.
Sir,
27. Mr.
Item
Murthy,
number 27.
Counsel for the petitioner submits that the bail petition has become infructuous as the accused has already been acquitted.
I could have waited because there is some other assignment. Therefore, I just made it.
Thank you very much. Thank you very much.
Obliged, my lord.
Yes. Any mentioning?
Your
Yes,
Lordship,
Mr.
item number 29 has a similar play to 27. The petitioner has been acquitted. Item 29.
29.
Yes, Your Lordship, he has been acquitted as well. So I was waiting for my turn. When I saw my senior taking a chance, I did it too.
You just see the fate of the bail applications. Somebody is acquitted, still we are not able to decide the application. This is unfortunate.
He was there in custody for a long time.
Yes.
The same same order as 27.
29?
29. Same order as 27. He has been acquitted in the mean. Lordships.
Yes, friends.
Pleasure.
Ms. Knight. Yes, thank you. Item 1.
Item 1, may I please, your lordship? I have a small prayer, my lord. First hour, second hour, my lord.
What is this? First hour, second hour?
My lord.
Your bail application is rejected.
My lord.
You are asking for
Small
crossing.
prayer, my lord. Only first hour, second.
Due to allegation.
I'm owner nahi.
120B. He is absconded since long.
Absconded. But
17.
But clear cut to the.
Your bail application rejected.
My lord. Small prayer, my lord.
When are you going to appear, you tell me?
As your lordship's director.
Learned counsel for the petitioner seeks to withdraw this petition, withdraw petition on instruction, and he submits that the petitioner would be appearing or surrendering before the trial court on or before
15 दिन भीतर है
on or before 20th of August, and avail his remedy under law. If the petitioner moves application seeking grant of bail, it is expected that the same shall be considered on its merit on the same day. Same day, everything is covered.
Parity if
Don't say that.
my lord.
Don't say that.
If
It is open. All the grounds are open. Why are you saying all this?
My lord,
A parity. If there is a parity, it will evaporate or what? Parity is always parity.
बहुत जहाँ allegation
It's all
are
right.
7 it's just to give observation.
And the petitioner is at liberty to take all the points raised in the present petition, including the ground of parity.
Item 2 and 3 on behalf of Mr. SP Das, my lord, have taken about 2 weeks after, my lord. He is suffering favor, my lord. On behalf of Mr. SP Das, my lord. The matter will be taken 1 week after, my lord.
Why? What is this matter? Let us understand.
Passing away fair. Anticipated application rejected.
Same order I will pass.
But 1 week after time instruction.
No, why unweek? See, the problem now you understood
My lord.
how the lawyers are mentioning. They are getting acquitted still. Why? Because of this reason. I will pass the same order. You go and appear, and because your application is rejected. Otherwise, I will have to dismiss. Huh? FR crossing, it's not possible. You know that. For the sake of filing, you are filing it. You know the investigation is still going on. Your anticipatory bail application is rejected. To what extent the court can help you? The petitioner has challenged. Petitioner has filed the present petition seeking quashing of the FIR number so and so under section so and so so and so. Investigation in the present case is still on. Therefore, the petitioner seeks to withdraw the present petition to avail remedy under law after the charge sheet is filed. After the charge sheet is filed. With this observation, the petition is disposed of. Yes, both the matters. Both the matter charge sheet is not filed.
No, man, that should not.
Both the matters.
Item 4.
Yes.
4, may I please, your lordship?
Yes.
Second matter, item 3.
Huh?
Sir, my lord, they have supplied a copy for deposition, my lord.
3 days after 1 week.
Arising out of 1/6 case.
1 CC case.
1 week after
Item 3 ta 1 week for a
My lord, my
2 days for at least 50% relief. Yes.
Item 4.
This is an appeal against conviction, my lord, under PC Act.
The sentence?
Maximum sentence is 1 year, my lord.
Okay. Admit
My lord.
reliance in a fine is stayed and bail granted.
Obliged.
I am here, my lord.
Call
I am
for record, and Mr. Sanjay Das is appearing for so and so and accept notice.
Obliged.
Yes. Copy. Supply a copy to Mr. Das.
Already supplied, my lord.
Yes. Mr. Ponda will be supplying another copy to you. Okay.
On 24th.
Name of Mr. Das will reflect in the court list.
Free copy is
24/7 I have supplied.
Free copy will you get. Okay.
obliged, my lord. Obliged.
Okay.
Item 5.
5.
Bail matter, my lord.
Hmm.
Bail matter, my lord. 307 and section 25. 25 Arms Act, my lord.
2022. This is
My lord, pending, my lord. Because, my lord, the petitioner having, my lord, 16 criminal antecedents.
Now, when the bail application was rejected,
Bail application rejected, my lord.
2/12/2020.
2/12/2020.
The bail prayer of the petitioner having been rejected by the learned Sessions Judge Jarsuguda on 2/12/2022, he has preferred the present petition. Since the bail petition of the petitioner was rejected way back in the year way back in the year 2022, I am not inclined to interfere in this matter. However, the petitioner is given liberty to approach the trial court afresh on the changing circumstances. If such application is moved, the same shall be considered on its merit. With this observation, the petition is disposed of. Yes, next.
Item 6.
Let him repeat the application. Much might have been changed now. Yes.
May I please, your lord?
Yes.
May I please, your lord?
Yes.
Bail application was the earlier, kindly tell the earlier order. I submitted the surety before the Hon'Ble Court.
When your bail application was rejected?
Bail was rejected on 27/7/2023.
1 year back. What is happening now?
Now the trial is commencing. Trial is going on. When IOAG.
After this impugn order, how many witnesses have been examined?
More than 3 to 4 witnesses.
Then you repeat your application. I am giving you liberty.
Minor. I obey.
Right. Then counsel for the petitioner seeks to withdraw the present petition to repeat his prayer before the trial court in view of the fact that his bail application was rejected by the trial court on 27/7/2023, and the trial has already proceeded thereafter. Hence, the petition is disposed of with the liberty display.
My lord, trial court is the SDJM, but bail application was rejected before the CBI London, CBI Bhubaneswar, CBI 1 Bhubaneswar. Trial is
And you want to go to trial court?
trial court is SDJM Bhubaneswar.
Yes, I have said only trial court, whichever is the trial court. Yes.
Bail is in the judicial custody last 1.5 years. My lord, any terms and conditions
So
may be
you immediately move the application. You don't get the bail, file a fresh one.
Only
Yes.
because the delivery, my lord,
Ah.
51 criminal antecedent similar.
You are very celebrated. You are representing a celebrated client.
And also, in advance, they have filed the my lord affidavit stating that they are ready to punish.
That is the direction of the Hon'Ble Court. I have filed the surety, my lord.
Anyway, you enjoy filing
Terms
their.
and conditions he may be released. My lord, any terms and conditions.
Okay, I have passed the order. You just see. Okay, next.
Item 7.
Yes.
7 my lord, 302.
Hmm.
498 husband. And there are allegations, direct allegations, my lord, and 90 to 92% born injury, my lord. And eyewitness there, my lord. And his prayer for
July 2020.
my lord.
Huh?
My lord.
Trial is on.
My lord, trial. Some of the four
This petition is
four
pending.
examined.
This petition is pending since about a year. The petitioner has challenged the order dated 20th Pudia, 2023, whereby the trial court has rejected his bail plea. Trial has already proceeded in this matter.
But
Which
four tests have been examined till 24/1/24. In the meantime, much more.
Trial has already proceeded in this matter. Therefore, it would be appropriate that the petitioner should repeat his bail application before the trial court on the change in circumstances. Circumstances. Therefore, the petition is disposed of with liberty. With the liberty. None appeals for the petitioner. With the liberty. Yes.
Item 8.
Yes, sir.
My lord, item is lost me disposal because the judgment was pronounced on 27/12/23. And the petitioner was convicted under section 302, life imprisonment is there.
This bail application is pending since 1/9/2023. Meanwhile, the trial has already been concluded and the petitioner has already been convicted for various offences. Therefore, this petition is infructuous, dismissed as infructuous. Yes.
Item 9.
9 permitted to withdraw.
Yes. Yes.
Item 10.
Please, my lord. My lord, the incident of 2016, there was no eyewitness, no evidence against the present petitioner. He is also languishing in custody only because suspicion, because there was a constant quarrel between the husband and wife. The dead body was recovered in the different places. There was not a single witness stated against me. And incident of 2016, out of 20 charge sheeted witness, only 7 of them have been examined. Impose any stringent condition. My lord, there is no criminal antecedent against the.
But whatever you are saying, that should reflect in the file. You show me from record.
Sir, rejection order, sir. Please see the rejection order. 1910-2000.
No, you said that witnesses have not supported the prosecution. Show me the.
That is also in the order sheet.
Yes.
Order sheet. During course of argument on counsel for the accused petitioner submitted that the accused petitioner being arrested in connection with the so and so. Prosecution story is that as per the written complaint of the informant, allegations alleging his cousin being killed by some unknown person who was living in separate house. This case was registered after completion of the investigation and submission of the charge sheet. As such, trial has already commenced. Some of the prosecution witnesses have already been examined, but before the court, there is no direct evidence against the accused petitioner. He further submitted that the accused petitioner is an innocent, law-abiding person in locality. By the time the occurrence, he was also absent the village by hurriedly without proper investigation. Police has submitted the charge sheet against him.
My lord, here the rejection order is 19-10-23. In the meantime, 8 witnesses are examined out of 20.
Yes.
You
In
mean
19-12-23,
that time when the rejection had taken place, that time only 4.
only 8, my lord.
That is
8
10,
witness.
23-10, sir.
Then, my lord, Honorable Court has directed on dated 18-4-24, my lord.
Hmm.
The London Court below to
Out of the deceased is
directed to send the copy of that deposition copy.
Deposition copy is there.
Deposition copies is available in your lordship's file, my lord.
That is there also. In the last occasion also, it was.
Hmm.
No, deposition copy you have not supplied.
Yes, yes, I have supplied. Please
Yes.
see.
Show me deposition. Eyewitness.
There is no eyewitness, sir.
What are the yes? What are the evidence?
Yes, what are the evidence against me,
Deposition
sir?
copy is not available with me. He has not supplied the
He has
deposition.
filed all these things. You have not given to.
Given, sir. I have given.
See, on merit it has to be decided.
Sir,
then you
sir.
give the copy.
I have given a copy. Last occasion the matter was there, Honorable Justice Mahapatra.
That's right. He says.
My lord, actually on 18-4-24, this court has directed to supply the court below to transmit the deposition copies to the court, my lord.
Then you collect it from here. What to do?
Well,
Well,
only-
whether it was supplied or not.
Yes,
that
it is there. PW1 to PW10.
yes.
Yes, your lords, I will collect.
Right on. Then Council for the State submits that the deposition copy which has been transmitted to this court has
Can I supply the deposition copy?
has not been supplied. Mr. Panda, Council for the petitioner, undertake to supply the copy of copies of the deposition during the course of the day. Leave the matter next week. Give a copy.
Sir.
On minutes. Yes.
Item 11, please, your lords. Last date, this honorable court directed me to file copy of the deposition.
Yes.
I have also served the copy of the deposition to my learned friend.
Do you have?
But just now we saw this.
Only
Inside the court, yes,
No,
sir.
only 2 sentences of the informant deposition may kindly see.
Yes.
Only
What is the offense?
offense under section
302.
302. The accused and the deceased both are two brothers. Due to civil dispute in between them, in several times they are quarreling to each other. On the day of occurrence, during tussle between the deceased and the accused, the deceased fell down on the sharp object. Spot inquiry report also reflected that there is a sharp object on the spot. And the allegation is that allegation has been filed, FIR has been filed by the daughter-in-law. This is the daughter-in-law, the bohu. The accused Narsinga Charan Sahu asserted to the rib of her father-in-law by means of a knife, for which sustained bleeding injury. Thereafter admitted to the hospital, and in the hospital he was dead. But fact remains, both deceased and his son were brutally assaulted to these petitioners. Annexure 4 is the annexure.
So therefore, that is the reason you have
ମୁଁ ଆଜି
attacked.
27 ଦିନରେ ଇଣ୍ଡୋର ପେସେଣ୍ଟ ହିସାବରେ ରହିଲି ମୋର ଏଇ ହାତ ଖସିଗଲା ଗୋଡ ଭାଙ୍ଗିଗଲା on the other hand only deposition copy of the deposition of the informant may kindly seen
Yes.
see again କହିଲା I had seen the occurrence from a distance from 10 to 12 feet no other person was present near the spot at the time of occurrence at para I also highlighted my kind of my I have also
You have not
highlighted in
filed
two-
here anything.
Again?
You have not filed anything here.
ନା ମୁଁ ଆଜ୍ଞା କିଛି ତ ଫାଷ୍ଟ
Hmm.
I was ଏଠି
Where are
para
you?
3
Para 3 of what?
para 3 of a deposition of the informant.
Which page?
Page 2. Page 2.
PW?
PW1.
I had seen the occurrence. I also highlighted to their two
Hmm.
sentences. I had seen the occurrence from a distance of about 12 to 10 to 12 feet. No other person was present near the spot at the time of occurrence. Next, the third page may kindly see. Para 4. I had not noticed the knife in possession of the accused prior to assault. 10-12 ଫୁଟ ଆଜ୍ଞା ଜଣେ ଲୋକ ଦେଖୁଛି ତା ପାଖରେ କୌଣସି ଅସ୍ତ୍ର ନଥିଲା। ତାପରେ
Abstractly you are reading one line.
My lord, kindly say para 2.
ପୋଲିସ ଆଜ୍ଞା ମଧ୍ୟ ସେ ଥିଲେ ତାଙ୍କୁ ମେଡିକାଲ ନେଇକି ଆକ୍ୟୁଜ ଯାଇଥିଲେ ଲାଷ୍ଟ
You are in custody since when?
ଆଉଟ ଆଜ୍ଞା
Custody 2522.
more than 2 years more than 2 years
2522.
What is the stage of trial?
Well, trial 10 witnesses he has supplied that copy. 10
Out- out
witnesses
to
were
90.
examined.
Out to
Informant is the eyewitness, my lord. Kindly see para 2. And leading to discovery that knife was seized from the present
Para
petition.
2 of who?
PW1, my lord.
Yes.
He's the informant, is the eyewitness, my lord.
Mhm.
The occurrence took place on 16/4/22 at about 3 p.m. in front of my house at village Tola Gopinathpur. At the relevant time, deceased was sleeping in our house. The accused arrived there and abused our family members in obscene words and threatening to kill us. My father-in-law came out of our house and protested such act of the accused. The accused had also come on several occasions prior to the date of occurrence and had abused us and had threatened us. On the date of occurrence, the accused had brought one crowbar with him. On protest by the deceased, the accused tried to assault him on his head by means of such crowbar. As such, the deceased caught hold the crowbar by means of his hand. It did not hit on his head. When the deceased snatched away the crowbar from the hand of the accused suddenly brought out one sharp knife, which he has concealed in his wrist, and perished the same on the left side chest of the deceased. The deceased sustained bleeding injury on his chest and fell down at the spot. Direct evidence there, and life was seized from the patient.
See, 10 witnesses have already been examined. 9 witnesses are there. I will give you option to revive your application after 3 months if all the prosecution witnesses are not examined.
My lord, just I place before my lord.
Direct evidence is
ନାଇଁ
there.
ଆଜ୍ଞା ଡାଇରେକ୍ଟ ଅଛି ସେ ଚିଫ୍ ରେ ତ କହିଲେ ସେ କଣ ନ କହିଥିଲେ ବି ପୁଲିସ କହିବେ ଆଜ୍ଞା ଏ ଲେଖନ୍ତୁ ସେ ଲେଖନ୍ତୁ ଖାଲି ଲାଷ୍ଟ ରେ ସେ କହିଲେ
It is a statement in the court, not 161 statement.
my lord ଜଣେ one police was accompanied with the accused persons but he has stated that may kindly see the last page of the deposition and ସେ କହିଛନ୍ତି I had accompanied the present accused to Niali medical at about 2 p.m. from Niali PS. At that time the accused was unable to stand and move due to his broken leg. ଗୋଡ ଭାଙ୍ଗି ଯାଇଛି ଆଜ୍ଞା ସେ ମେଡିକାଲ ଅଛି ପୁଲିସ ତାକୁ ଜଗିଛି ଆଜ୍ଞା ସେ ଛୁରୀ ଭୁସି ଦେଇ ଦୌଡ଼ି ପଡିଲା କେମିତି
This is the problem.
trial.
The fact that you have been beaten by them is the reason for you to kill him. That's what the case is.
ଆଜ୍ଞା ଏଥିରେ
It's double edged weapon, you know.
Double weapon. And
PW1 also stated that I have not seen the seizure of knife from the possession of the accused. ଏ କଥା ମଧ୍ୟ ସେ ଆଜ୍ଞା କହିଛନ୍ତି ତାଙ୍କ ପାଖରୁ ଛୁରୀ ଆସିଲା ନାହିଁ ମୁଁ ଛୁରୀ ଦେଖି ନାହିଁ
You have 27.
27, my lord.
Disclosure.
My lord.
2 ବର୍ଷରୁ ଅଧିକ ଆଜ୍ଞା ରହିଲାଣି only dispute in between two brothers due to
Revive after 3 months.
And
If the prosecution evidence is not concluded, you within 3 months you conclude.
My lord, only 10 witnesses examined out of 21.
19 you say.
19
21 witnesses.
19 ତ ଅଛି ମୋର out of 19 10 was
Right on.
My lord, in the rejection order, my lord, can see that out of 21 charge sheet witnesses, only
Where is
9
that?
witnesses have been examined.
Where is that?
My lord, page 24, Annex 5. That's the rejection order.
19, yes. Where is that?
My lord, last paragraph. Peruse the case record. Out of 21 charge sheet witnesses.
Where is that? Peruse the case record. Out of 21 charge sheet witnesses, only 9 witnesses. 9 witnesses into November 2023. So then.
So now he has given supplied 10 numbers of witnesses are examined.
Maybe
So only 11 witnesses are there. Your lordship may dispose of granting that within 4 months or 5 months.
Right on. At the time of rejection, on 16/11/2023, the bail plea of the petitioner has been rejected. The petitioner is in custody since
2522.
2522. By the time the bail plea was rejected by the trial court, 9 witnesses were already examined out of 21 witnesses. 21 witnesses. The petitioner has taken me to the evidence of the informant and submits that the petitioner himself was injured, was ruthlessly beaten by the deceased and his son, as a result of which he lost one of his amputed hand. Broken. What is the injury he received?
injury again.
Tell me orally. Brutally assaulted, as a result of which he was admitted
Injury to staff.
and admitted 1 minute, admitted to hospital for how many days?
27 days.
27 days. He is basically as a result of the assault by the deceased and his son, he becomes deformed. Therefore, there was no question of he being fled away from the spot after giving knife blow to the deceased. And he also relied upon the statement of other witnesses to point out the contradictions in the testimony of the witnesses. I am of the considered view that since the trial is proceeding at a expected pace, the petitioner should revive his bail application after 3 months if all the prosecution witnesses are not examined by then. With this observation, the petitioner is disposed of. Within 3 months, if they don't conclude, revive your application. And after 3 months, you will get it. They don't do it. After 3 months, you will get the bail if they don't do it.
My lord, after 3 months, after submission of that certified copy of this order, my lord.
Obviously.
Otherwise, he will keep this order in
certified copy?
Certified copy of this order.
3
months from the date of submitting the certified copy of this urgent order. Otherwise, he's right. You will hold it, and after 3 months, you go but this order will automatically go. Otherwise, also it will go. Still, I am writing that.
Postmortem
And
due
subject
to
and
hemorrhage and
and subject to condition that the petitioner shall not seek any adjournment.
My lord, as per postmortem report, cause of death hemorrhage and shock. माने ब्रेन हेमरेज कला पड़ी गला परे वयस्क लोक पड़ी गला परे आगे हेमरेज करछि
बॉयस कौन केते बॉयस
मोर देन 70 खंड हो दी भाई आगे भाई की तो आसी सान भाई के हेलानी आसी की तो 50 57 वर्ष 57 माने ताकू निहाती 65 70
I think you may get acquitted
hemorrhage and shock
but you may get acquitted also because within 3 months everything will be over. But that is a better idea too. Yes.
Yes. Item 7, my lord, I'm free for adjournment and supplying the deposition copy of the.
Who is 7? 7 has gone long way. Dispose of. Liberty. You move fresh application. Fresh application with all deposition. I have given liberty. I have protected your entire right. Don't worry.
Some of the witness have been
Therefore, I'm saying. Therefore, I have written all these things. Don't worry. You will see the order. You will be happy.
Non-appearance.
Non-appearance Korani. The kind of non-appearance Korani. The clients will say that the lawyers are not going, therefore the orders are passed. Kind of non-appearance Korani, appearance Korani. Why should the lawyer will be getting?
Today also rainy day for that is some today also heavy raining matter.
Heavy rain for any reason they might not have come. Yes, sir. But I protected you. Right, don't worry. Yes, sir.
Well, may I please yours? Madam, the case is under section 20B2C of the NDPS Act, madam, and the petitioner is in custody since 22 March 2023. That is 1 year, 4 months, 9 days, madam.
Yes. Recovery,
madam. The present petitioner was the driver of the offending vehicle, and the contraband article has been seized from the dicky of the offending vehicle, madam.
How much?
That is 100 kg, madam. 100 kg.
And only person inside the car.
Madam, only person. My humble submission is that. My humble submission is that, due to delay in trial, also, he is liable to be released on bail. Recently, the Honorable Supreme Court in Ankur Chaudhary versus State of
the FIR was lost when?
By 22 March 2023.
23 what delay?
More than 1 year,
1 year.
What is the stage of trial?
Already it was posted to 8/8/24 for evidence. 8/8/20.
Who all are the main witnesses?
Madam, only official witnesses are there, and one is independent witness, madam.
Who is that?
His name is
Seizure witness.
Seizure witness, madam. One is seizure witness. Madam, kindly posted the the trial has been commenced recently, madam, and the case is posted.
What I say is, after the independent witness is examined, you revive your application.
I will take instruction, madam. It's because the case is posted on 8th.
No, I'll what to instruction? I'll protect your right. You revive your application after the independent witnesses are examined. Because official witnesses you can't influence.
My humble my humble submission is that manner. Whether the prosecution has examined or not, I will take it.
If it is examined is good, then you can revive your application. Right now, the present petition is petitioner is agreed by the order dated 14/11/2023, whereby his application for grant of bail has been rejected. The trial is proceeding at its expected pace. However, the seizure witnesses, however, the independent witnesses have not yet been examined. Therefore, therefore, I am not inclined to entertain this petition at this stage. However, I give liberty to the petitioner to revive his bail application after the independent witnesses are examined by the trial court. With this liberty, the petitioner is disposed of. You immediately move the application, independent witnesses are examined, then you have a stand. Yes.
Item 13.
Yes, sir.
The allegation is here in this case under section 302, 307, 120B IPC.
Yes.
There are two petitioner my lord here in this case. One is Rajesh Mahapatra and another is Gedu, alias Ajay Kumar Raut. The allegation is that my lord, while the victim and his the informant and her husband sleeping at in front of PMG Square, the present petitioner Rajesh Mahapatra went to that spot and assaulted by way of iron rod. On this same day, the person died. This is the allegation, my lord. As far as the present petition number 2 is concerned, in fact, there is no allegation against petition number 2. The allegation against petition number 2 is that he has intimated the matter to Gedu, the present petition number 2, and on his presence he has assaulted. This is only
Raju has assaulted. Raja has assaulted, and Gedu was only present.
Only present. Yes. This is the allegation, my lord. The case is
show me the allegation, show me the medical report.
My lord.
Corresponding injury.
My lord.
You show me, then you have a case.
My lord, as far as injury is concerned, my lord.
Injury report you show me.
My lord.
And show me the allegation.
My lord, injury report is on the post-mortem report, my lord.
Now, where is that?
PM report is, my lord, cerebrovascular injury.
Which part of the body? What there is weapon used and what is recovered from Gedu?
Iron rod was seized
from Raja, who has given the blow.
From the petition number 1.
What about Gedu?
Raja, my lord.
What about Gedu?
Raja and petition number 1 and 2, both were came and they were assaulted. But the two persons were, one is died, my lord, husband was died, wife was injured, grievous injury is there.
What
and wife has stated
Gedu was holding anything?
No, my lord, no, my
1 minute.
My lord, I am reading the statement of the injured wife.
Read it.
Well, she is the only eyewitness.
My lord, Pooja Behra, she is the eyewitness, my lord. আজি 12/4 ରେ କଟକ ବଡ଼ ମେଡିକାଲରେ ଚିକିତ୍ସିତ ହେଉଥିବା ବେଳେ ଆପଣଙ୍କୁ ଏହି ବୟାନ ଦେଉଛି ଯେ ମୁଁ ପ୍ରାୟ 3 ବର୍ଷ ତଳେ ଚଣ୍ଡିଖୋଲ ପାଖ ପୁରୁଷୋତ୍ତମପୁରରେ ରହୁଥିବା ବେଳେ ବବୁଲ ବେହେରାଙ୍କ ସହିତ ପରିଚିତ ହୋଇ ତାଙ୍କୁ ବାହା ହୋଇଥିଲି। ମୁଁ ଛୁଆ ଦିନ ଘରୁ ବାହାରି ଆସି ମୋ ମାମୁଁ ଘର ଖୋର୍ଦ୍ଧା ପୁରମପଦାରେ ରହୁଥିଲି। ସେମାନେ ମଧ୍ୟ ମୋତେ ଭଲରେ ନ ରଖିବାରୁ ମୁଁ ଚଣ୍ଡିଖୋଲରେ ଥିଲି। ମୋର ଗୋଟେ ପୁଅ ହୋଇଥିଲା, ତାର ବୟସ 2 ବର୍ଷ ହେବ। ଚଣ୍ଡିଖୋଲରେ କାମ ନ ମିଳିବାରୁ ଆମେ ଭୁବନେଶ୍ୱର ଆସିଗଲୁ। ଏଠି ରହିବାକୁ ଜାଗା ନଥିବାରୁ ପିଏମଜି ପାଖ ପୋଷ୍ଟ ଅଫିସ ଆଗରେ ଥିବା ଏକ ଏଟିଏମ୍ ବାରଣ୍ଡାରେ ଶୋଇପଡୁ। ଆମେ ଏଠାରେ ପ୍ରାୟ 3-4 ମାସ ହେବ ରହୁଛୁ। ରାଜେଶ ମହାପାତ୍ର, ଯାହାକୁ ରାଜା ବୋଲି ଡାକନ୍ତି, ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ନମ୍ବର 1, ଓ ତାର ସାଙ୍ଗ ଗେଡୁ, ପିଟିସନ ନମ୍ବର 2, ଯାହାକୁ ଅଜୟ କୁମାର ରାଉତ ଆମର ପରିଚିତ, ସେମାନେ ବେଳେ ବେଳେ ଆମ ପାଖକୁ ଆସନ୍ତି। ଗତ 10/4/22 ଦିନ 2ଟା ବେଳେ ରାଜା ଆସିଲା ଓ ମୋ ସ୍ୱାମୀକୁ ଖରାପ ଭାଷାରେ ଗାଳିଗୁଲଜ କଲା। ମୋ ବିରୁଦ୍ଧରେ କହିଲା। ମୋ ସ୍ୱାମୀ ତାକୁ ବି ଗାଳି କଲା। ମୁଁ ଆସି ରାଜାକୁ କହିଲି, ମୋ ବିଷୟରେ କିଛି ଖରାପ କଥା କହିଲେ ଠିକ ହବନି। ମୋ ସ୍ୱାମୀ ରାଜାକୁ କହିଲା, ଯଦି ଅଧିକ କହିବୁ ମୁଁ ତତେ ଦେଖିନେବି।
ରାଜାକୁ କହିଲା।
ରାଜା ସେତିବେଳେ ସେଠାରେ ପାନ ଦୋକାନରେ ଥିବା ଲକ୍ଷ୍ମୀଧର ଭାଇ ଆସି ରାଜାକୁ ପାଟି କରି କହିଲେ, ଏଠାକୁ ଆସି କାହିଁକି ଝଗଡା କରୁଛୁ? ରାଜା ରାଗିକି କହିଲା, ମୁଁ ଯାଉଛି। ଗେଡୁକୁ ଡାକି ପିଟିସନ ନମ୍ବର 2 ତୁମ 2 ଜଣଙ୍କୁ ଦେଖୁଛି ବୋଲି କହି ଧମକେଇଲା। ସେଦିନ ମୁଁ ଓ ମୋ ସ୍ୱାମୀ ଖାଇକି ଗୋଟେ କନ୍ଥା ବିଛେଇ ଏଟିଏମ୍ ବାରଣ୍ଡାରେ ଶୋଇଲୁ। ମୋ ପୁଅ ଆମ ପାଖରେ ଶୋଇଲା ବେଳେ ମଶାରୀ ଟାଙ୍ଗିଥିଲୁ। ରାତିରେ ମୋ ସ୍ୱାମୀର ଚିତ୍କାରରେ ମୋ ନିଦ ଭାଙ୍ଗିଗଲା। ଦେଖିଲି ରାଜେଶ ଗୋଟେ ଲୁହା ରଡ୍ ଧରି ମୋ ସ୍ୱାମୀକୁ ମାରି ଚାଲିଛି। ସେଠାରେ ଗେଡୁ ବି ଥିଲା। ରାଜେଶ କହୁଥାଏ, ମତେ ଧମକ ଦବୁ, ଏତେ ସାହସ, ଏବେ ମୋର କହି ମାରୁଥାଏ। ମୋ ପାଟି ଶୁଣି ଗେଡୁ ରାଜେଶକୁ କହିଲା, ପୂଜା ଉଠିଲାଣି, ତାକୁ ବି ଶେଷ କରିଦେ। ପୂଜା ଇଜ ଦ ୱାଇଫ ଅଫ ଦ ଡିସିଜ୍, ଇନଜୁର୍ଡ ୱାଇଫ। तापर राजेश से रहर मोर मुंड और मुह को पिटी चलला मोर तार माड़े चेता पलैला सका चेता आसबार देखिली मो स्वामी मरी जाइछन्ती आ मो पुओ गोड़ पाखरे बसी कांदुची किछि समय परे एम्बुलेंस रे आसी मते मो पुओ को मेडिकल नै गले सेटार मते सेटा कटक मेडिकल नै गले एठी मु चिकित्सा होची then my lord injury she has sustained grievous injury and my lord against the present petition number 1 there is 3 numbers of antecedent against the petition number 2 there is 1 antecedent that is relating to 302 my lord. He was involved in another murder.
Well, this is a case of the year 2022.
But the
And
brutal-
till yet, yes, my lord. I am not pressing the matter for the petition number 1. As because I have gone through the entire record, that is allegation against
Petitioner number 2 has an antecedent.
No, my lord, petition number
2 has 302 case.
302
well, of the year, my lord, I have not verified.
Whatever it may.
Well, in fact,
you
here
you are a murderer and you are instigating another murderer.
no, there is no instigation on the part of the petition number 2, my lord, here in this case.
You Lalkara, that is
No, my lord, he has only he has not assaulted the victim or the deceased, my lord. Only allegation is he was present there. This is the allegation and
present there and Lalkara, that you see the what is the role of a Lalkara accused. Instigation. Puja ko bhi maar diyo.
My lord, that has been added, my lord. In fact, that as part of this is my lord in order to
everything is all right. You are maybe entitled, but the problem is you are
2002 trial has not completed till yet.
Antecedent. What about the other case?
Trial has not completed till yet.
The other case where he is an accused.
Other case, my lord, that instruction I have not collected. Only that in antecedent in 2013, 302, my lord.
302.
My lord. Whether in what?
What is the stage of the trial now?
Not
trial, my lord.
This lady is examined.
It was posted to 13/8/24.
The lady is examined.
That instruction I have not collected, but from the website I got that it was posted to 13.
But unless this lady is examined,
my lord, 2022 case, my lord.
No,
till the trial has not commenced. My lord,
unless the lady is examined, I can't.
My lord, as far as Rajesh is concerned, my lord, I will place the matter after examination of the informant, my lord. As far as Gedu is concerned, my lord, in fact there is no allegation. Nothing has been seized from the possession of the present
regarding head to the allegation made against the petitioners are accused in FIR number so and so. The charge sheet has already been filed. Petitioners are in custody since 13/4/2022. Trial is in progress. Regarding head to the allegation made against the petitioner number 1, I am not inclined to grant bail to him at this stage. Insofar as petitioner number 2 is concerned, he has, although he has not given any blow to the petitioner, he was blow to the deceased, and he was even not armed with any weapon. However, he has, and after the assault by the accused number 1, he has instigated the accused number 1 to assault the wife of the deceased, as a result of which accused number 1 has assaulted the wife of the deceased, who had received serious injuries and got hospitalized on the next day. The deceased died at the spot. In view of the same, insofar as petitioner number 2 is concerned, he can revive his bail application only after the examination of the
informant,
wife of the deceased, namely informant in this case. Informant in this case. With this liberty, the petition is disposed of. You immediately and Council for the State submits that he would ensure that the informant is examined as expeditiously as possible.
My lord, as far as Puja Vera is concerned, her whereabouts is not known, my lord. ମାନେ ସେମାନେ ବେଗାର ମାନେ ସେ PMC ଆଗରେ ଶୋଉଥିଲେ ଯୋଉ ସେମାନେ ସବୁ ବେଗିଂ କରନ୍ତି ସେଠି ଶୁଅନ୍ତି ମଶାରୀ ଟାଣିକି। ସେଇ ଯୋଉ ଶୋଇବାକୁ ଜାଗା ନେଇକି ତୁ ମୋ ଜାଗାରେ କାହିଁ ଶୋଇପଡିଲୁ, ମୁଁ ଗାଁକୁ ପଳେଇବି ତୁ ମୋ ଜାଗାରେ ଶୋଇପଡୁ, ଏଇ ଯୋଉ ଗଣ୍ଡଗୋଳ ଏଇଥିରେ ସେ ଗଣ୍ଡଗୋଳ ଆକ୍ଚୁଆଲି ହେଇଛି। ଇନଫାକ୍ଟ ଗେଡୁ ନାଁରେ କୌଣସି ଆଲିଗେସନ ନାହିଁ। ଗେଡୁ କାହିଁକି ତୁ ମତେ କାହିଁ ହେଲ୍ପ କରୁନି କି ତାକୁ ମତେ କୋଅପରେଟ କରୁନି, ମୋ ପକ୍ଷ ନେଲୁନି, ସେ ଯୋଉ ତାକୁ ଏଣ୍ଟାଗଲ କରାଗଲା ନା
Charge when the charge was framed?
Charge framed on the date no 29/4/2022.
Right on. It is expected that the informant in the present case.
Well, informant here in this case is police.
No.
Police
Then
is the
the
informant.
wife of the deceased.
Puja Behra.
Puja
Behra.
Behra. Right. The eyewitness and the independent witness is examined by the prosecution within 3 months from today. Within 3 months from receipt of the present order. Within 3 months you examined. Otherwise, see, in so far as Gedu is concerned, he is entitled for bail.
Entitled only
Except the fact that he has an antecedent.
Antecedent under section 302. That is
prior to the incident, that is there was
You are entitled.
meeting of mind or other thing.
Gedu is entitled, but Raja.
Let him may be granted bail, my lord. He is an innocent fellow, my lord.
No, but the problem is if this lady is not examined, he will definitely influence. Very dangerous. Because they are friends. He will influence. So therefore 3 months I guess. Yes. Next.
Item 40. Item 14, I filed while I for interim bail. So both the kidneys have been damaged, my lord, and one and health condition is my lord deteriorated. So that's why my lord I filed my lord.
What is the main case? Tell me.
Main case is that based on my lord supplementary case of 302. 302 case is the case of health case is down based on circumstantial evidence. Initially, case was registered. Gunpur PS case number 82 by 2000 82 by 2023 with an allegation that while one Gauri Mishra sat on the Bansundara river along with his friend, some unknown person came and shot fire. That is the case. Subsequently, one he Lakshmi was deposed in 161 statement that his son B Raja has made an extrajudicial confession that I have taken. There are some dispute between the petitioner family as well as Gauri Mishra regarding land dispute. He had taken some power of attorney and grabbed some landed property. So he contacted my lord, as far as confessional allegation is there. He stated he came in contact with B Raja. He stated that they will take 30 lakhs to kill my lord Gauri Mishra.
Contract clear.
My lord, this is just like a film story, my lord. That's the present petitioner is the principal accused. His family have some dispute. His family has some dispute with that deceased Vibhuti Mishra. That deceased my lord Gauri Prasad Mishra. They have given supari to one V Rajesh. And deal was fixed, my lord, 30 lakhs. And advance was given 2,90,000. Subsequently, V Rajesh and Munna Lima, of the 3 persons, they killed the deceased. Then after, my lord, that supari killer, he told the present petitioner that if you will not give me 1 crore rupees, then I will disclose all these things. Then the present petitioner and his friend, they called that supari killer to Hyderabad. That you will come and you will take, we will give 1 crore rupees. At Hyderabad, my lord, in his gun, that the supari killer gun, the present petitioner and his friend, they have killed that supari killer. And thrown that gun and buried his, leading to discovery that gun was seized from the present petitioner.
There is no such direct allegation, nothing, only confessional statement. But my friend is saying only when they arrested.
The recovery is there and everything.
Leading to this, yes, gone and that dead body. Gone and dead body of that supari killer. It was recovered in the instance of that present petition. There is two cases, my lord. In one case, he has
That
conspiracy.
Govinda Mishra.
That Gauri Mishra.
Gauri
They are
Mishra.
killed. They are giving super killer.
The Gauri Mishra case is also, there are two
cases, my lord. Gauri case, he was conspired and he given supari to the present petition.
And
Another
killing
case,
supari-
he killed with the supari.
Conspiracy, there is only.
What happened to that case? You got the bail.
Some co-accused person has been released.
What about you?
My lord, that is pending also called for city court.
No, that in that matter also you are not
My
got.
lord, in that case, in Gauri Mishra, that case, my lord, in which they have conspired.
Your lordship, this
Circumstances speak truth.
no
Witness may not.
circumstances that is
Some
based on
persons
not
were
the
granted bail.
witnesses.
If the strong circumstances
There is
is
no
much
strong
more dangerous than
only
witness.
non-confessional.
My lord, in that
is-
cases,
that circumstances is its own confession.
some persons were released on bail.
27 the recovery.
27 dead body টা রিকো সেটা develop
Dead body and gone.
And
ସେମାନେ
gone.
ସେମାନେ
My lord, some persons are released on bail. I was
Bail,
conducted
my
that case, my lord.
bail-
And they were
Which
only
one?
allegation is
Supari killer thing or the
no, and that death case, my lord. That because they have no, I have
why you are
conducted
not
this
getting
case.
bail there?
ମାନେ ସେ ଦିଟା କେସ୍ ଏଇଠି ଅଛି ଆଉ ଗୋଟେ କେସ୍ ଅଛି ଏଇଟା ଅଛି ସେ କୋର୍ଟ ମୁଁ ଫାଇଲ କରିଛି ତାର ରେନାଲ ଆଇ ଦେଇଛି ସେ
Very good.
ମେନ୍
That the instruction, 28(1) in 24, my lord, there is one instruction is there.
ନାଇଁ ନାଇଁ ସେତେ ଦେଇଛି ଆଇ ସେତେ ଆସିନି ତ କହିଲି ଆଇ ଦେଇଛି
I said, asking
Check it out. Copy, you give the copy.
Man, court copy रे भी नहीं है.
In the which IA is this?
আই নম্বর মানে
1601 23. The petitioner is seeking interim bail on the ground that he has been suffering from what?
renal problem kidney my bad
On the ground that his both the kidneys have damaged
and one has been transferred by his father jone ta bappa
and one of the damaged and one kidney has been transplanted. Kidney has been transplanted. Therefore, he is not he is terribly ill. We issue notice to the state to verify the fact of the illness, verify the medical document filed by the petitioner. List on next.
My lord, actually, he has filed this I on 29/11.
very present status
23. And we have already obtained instruction.
What
right?
is that?
My instruction is that, my lord, he is suffering from renal disease and has undergone a renal transplantation kidney. And his health condition is, my lord, the said patient prisoners is now found normal after receipt of the opinion from the expert from the MKCG Medical College and Hospital. So he is in normal condition. That is the instruction we have obtained, my lord.
ନା ପ୍ରେଜେଣ୍ଟ କଣ୍ଡିସନ ବର୍ତ୍ତମାନ ତା ଖରାପ ଅଛି
ଓ ଆଇଟା ଦେଇଥିଲେ ସେଇଥିରେ ତ instruction ଆସିଛି, ପୁଣି
ଭେରି ବିଗିନିଂ ଫାଇଲ କରିଥିଲି
ଏବେ କଣ ଦିଅନ୍ତୁ ତାହେଲେ
ବର୍ତ୍ତମାନ କିଛି ଡକୁମେଣ୍ଟ ଦିଅନ୍ତୁ ଭେରିଫାଇ କରିବି ନହେଲେ
Yes, yes,
ଯୋଉଟା
sir.
ଯୋଉ ଡକୁମେଣ୍ଟ ଦେଇଥିଲେ
ସେ
ଭେରିଫାଇ
bill-
କରିସାରିଲେ
ମୁଁ ଦେଇଦେବି ଆଜିର in course of the day I will submit
seeks
something.
to file fresh
Yes, sir.
medical
Document.
document
Yes, sir.
regarding the same.
Yes, sir.
The copy of the same shall be supplied to the state council for verification. These
Yes.
Well, if you will supply the your lordship take up this.
Why don't you do one thing? Why don't you go to trial court?
No, well, it is sanctioned to use.
No, I will dispose it up. Go to the trial court and
Cross case renewal.
ମୁଁ ଦେଇଦେବି ଆର କେସଟା ବି ଅଛି ଦିଟା ଯାକ ତେଣୁ ସାଙ୍ଗସନ୍ ଦେଇଦେବି ଅଛି ସେ ପଠେଇ ଦେଇଛନ୍ତି
but you are on merit. You are not entitled to pay.
your lordship whatever you say but so far as
Okay, they will.
If you will supply an interim application, then I will take an instruction. Otherwise, maybe it will be listed. You on that day will supply the instruction.
Do you report? Yes.
15.
Yes, Mr. Patel.
Yes, of 3762N, my lord. And subsequently, DNA test also conducted. The victim has her blessed one female child, and DNA test also corroborated, my lord. And during the charge sheet, my lord, it was found that the Victim is SC category, my lord. That's why notice has been served to that effect, my lord. This is the order of the trial court, my lord.
Whether the victim has already been examined?
No, my lord. The charge yet not framed, my lord. Today is the consideration of the charge, my lord. And once the petition,
DNA report has gone against you.
my lord.
After the examination of the victim, you
My lord, only pray, my lord, once this petitioner granted interim bail, my lord, and in time he has surrendered, my lord. Praying for the settlement, my lord. Only 1 month maybe. Only 1 month maybe.
Settlement in 376. What?
Both are labor, my lord, and concerned in
That's
nature.
right, but you outside you can do it. What is the impact? I don't know. How will you?
Once
the court can't ask you to do it.
No, my lord.
376 DNA
only,
test is proved and everything is there.
And on dated 18/12/2023, the petitioner also granted interim bail, my lord, and surrender in time, my lord.
That's right. That is inure to your benefit. No problem. You are in custody since August.
August, yes, my lord.
How much time will you take to examine the victim?
My lord, I'll take Mr. Smith.
Best thing I'll tell you, best thing, Mr. Padi, is
My lord.
I'll fix 3 months. I'll tell you this, if you are really settling, go and settle. If that lady will go and depose in your favor on the after settlement, you will be acquitted. Unnecessary, why are you going?
My lord, only praying for
this is
one.
the practical thing.
Yes, my lord. Both are labor, my lord.
I know, therefore, that is the reason I'm saying.
My lord, only 1 month, my lord. Only 1 month maybe.
No, 1 month, the charge has not been framed. So
today is for the charge, my lord. Today is for the charge.
Today posted for charge.
Only 1 month, my lord. Gote thara jai ki bhi surrender kariche se.
Put it on Monday.
Oblige, my lord.
Monday, you tell me whether charge is.
Yes, my lord.
Then we will consider.
Yes, my lord. Yes.
Okay.
Oblige.
Monday, you must come with.
Yes, my lord. Yes, my lord. Yes, my lord.
Charge.
Copy, my lord.
Copy.
Today's order copy.
Monday.
Oblige.
Monday. And meanwhile, you try to settle. Yes.
May I please?
Yes.
Under section on 376(1) of IPC,
Yes.
custody since 29/7/2023.
Yes.
And charge sheet has filed, and the petitioner is petitioner and the victim are both at the age of 50, my lord.
Down to 164 statement. Read it. Read. Annexure 422.
My lord.
Page 22, Annexure 4, 164 statement. Read it. Have you prepared or not?
Yes, ma'am.
Read it.
26/7/2023 ପ୍ରାୟ 12ଟା ସମୟରେ ମୁଁ କିରାଣୀ ଦୋକାନରେ ଚା ପିଉଥିଲି। ଆମ ଗ୍ରାମର ଗୋପାଳ ପ୍ରଧାନ ମୋ ପାଖକୁ ଆସି କହିଲା ଧାନ ରୁଆ ହେଉଛି, ବିଲକୁ ଯିବା ଆଉ ମତେ ଗାଡିରେ ବସିବାକୁ କହିଲା। ମୁଁ ବସିକରି ଗଲି। ମତେ ଆମ ଗାଁର ଜଗନ୍ନାଥ ମନ୍ଦିର ପାଖରେ ପଡିଆକୁ ନେଇ ରେପ୍ କଲା। ମୁଁ ପାଟି କଲି ଓ ତାକୁ
almost 9 witnesses had been examined. Out of them, 2 witnesses, that is Pavitra Naik and Vibhuti Banyodeo, are alleged eyewitness and they are witness to the TI parade. They have been examined and they do not support the prosecution case. It is the evidence of Pavitra Naik that I was examined by police regarding this many times. I cannot recall whether I have stated before police regarding this case on 5/4/2023. He has been examined on 5/4/2023, then 10/4/2023, and his 164 statement was recorded on 18/4/2023. And he has stated in paragraph 5 that on that day there was no light outside the office and it was light darkness outside the office.
You tell me one thing. After 2/9/2023, how many witnesses are examined?
9 witnesses.
Huh?
9.
Then you apply a fresh to the trial court. Right on. Petitioner is reviewed by the order dated.
I hope that the trial will not entertain.
1 minute. The order dated 2/9/2023, whereby his bail plea has been rejected by the trial court. Meanwhile, 9 more witnesses have already been examined. Therefore, the petitioner, I am of the principal view that the petitioner should revive his bail application before the petitioner should renew his bail application before the trial court. If the petitioner moves such application in place, the same shall be considered on the basis of the evidence which has recorded. With this observation, the petitioner is disposed of. Yes, you revive your bail application, and I have given a direction that the trial court should consider all the evidences and dispose of. Yes, next one. Yeah.
May I please answer?
Yes.
Sir, allegation is 376D.
Yes.
The notice has been sent to victim. So IO, there are 2 accused, sir. I am one of the accused, Nakpuri John. The allegation is, according to complainant, while he was going to bathing in Kondanalo village, Jamudia, suddenly 2 accused person came and forcibly put her to complainant, and they take out a nearby bushes and forcibly raped her one after one. Yeah. In meantime, the charge sheet had been submitted and charge firm has been also laid down. My submission is that the evidence of medical report does not support this case.
Yes.
My submission next.
Show me the medical document.
Sir, page number 70, para 22.
70?
Yeah, para 22. Local examination of genital part and other orifices. Ethereal major and vestibule intact, labia major intact, and all this.
Whether the prosecutrix has already been examined by the trial court?
Notice has been sent, but the complainant does not turn out yet. She was awaiting the trial.
Yes, prosecutrix has been examined.
My lord.
No.
Examined.
No, my lord. That instruction is to be obtained, my lord. No instruction.
Examine the prosecutrix. The trial is on, huh?
No, my lord, that instruction is not there, my lord. I will take instruction.
The trial is going on.
Yes, sir. Charge frame has been framed. Notice has been sent to for evidence to complainant, but she did not turn out.
Okay, then what I'll do is I will give you an opportunity. 1 minute. I'll give you an opportunity to revive your bail application once again after the recording of the evidence of the prosecutrix. If that is not happening within 3 months, then you can very well move another application. Right. But see, the allegations are very serious.
Medical
report that girl by closing her eyes and everything, and you took near the bush and raped her.
Submission, if rape is possible, there is either external injury or internal injury. There is no absolute injury.
But prosecutor's version has to be seen. 164 is recorded.
Yes, madam.
Where is that?
My lord.
Show me one. Show me 164. Page.
That is CD. In CD, my lord, that 164 statement I have submitted.
You can read it. You could not read, therefore conveniently pass on. He could not read it, so therefore conveniently pass on. Is there, have you, he has filed, the petitioner has filed?
Petition not filed, madam.
Not filed. Have you filed the 164 statement?
No, sir.
Not entitled, my lord.
I have not opted.
Newspaper suppliers for that, they have not.
See, they have more document than the prosecutor. Why do you worry about it? You do one thing, you wait till the prosecutor is examined.
My lord, after examination of the victim.
The petitioner is agreed by the order dated. 1 minute. The petitioner is agreed by the order dated. Which order? Rejection? Order dated 25/9/2023, passed by the learned trial court, whereby his bail plea has been rejected. The petitioner, first petitioner is accused in FIR number 4. It is stated at the bar that the prosecutor's in the present case has not yet been examined. And counsel for the petitioner submits that the testimony of the case submits that the prosecutory version as reflecting in the 161 statement, as reflected in the 161 and 164 statement cannot be believed in view of the medical evidence which has come on record. I am not inclined to entertain this petition as this case. However, the petitioner is given liberty to renew his bail application after the prosecutor is examined. And counsel for the petitioner further submits that despite repeated notice to the prosecutor is not appearing in the court for recording of the statement. In that view of the matter, the petitioner is also given liberty to move the bail application after 3 months. After 3 months, in the event cell, the prosecutor is not examined by that time. With this observation, 3 months, or the prosecutor is examined, whichever is earlier, you apply. Yes, next.
This is a case wherein the petitioner is in custody for last 12 years. Now,
12 years.
12 years.
It's a matter of 2012, madam.
What I said, the nature of allegation, lordship, road blockage from Narayanpatna to Lakshmipur. This is the only allegation.
Who are you?
No, they say that people stop the roadways.
Are you not covered by 336 capital A?
336 capital A.
Where is here?
They say that.
See 336 capital. 336. Am I correct? 336 or yes, 330 must be. Okay, you remember 336 capital. Where is the new way? Here, where is the new one? New Act.
New Act, madam.
There is an amendment to 346 or 330?
436.
436. I vaguely remember the
New Act.
436, na? 436. Yes. 436.
There are judgments of this court.
36, capital A. Yes, just see. Thank you for reminding me. I am thinking of 336. Okay.
Miss Visramala.
See his update in all provisions. Yes.
This is maximum period for which an under trial prisoner can be detained. Where prisoner had during the period of investigation, inquiry, or trial under the code.
If you have crossed 50% of the sentence, likely to be given to you.
Here, my
Then
lord,
you are
the
entitled.
trial has not begun. Last 5 years, date has been fixed for framing of charge.
What do you say?
And the allegation.
My lord, rejection order shows, my lord, that investigation that charge sheet
Forget about
submitted,
whatever. 12 years is
22 accused persons showing absconder, my lord.
whatever.
Not 22%.
17 accused persons, including the present petitioner as absconder, my lord.
He is absconder.
Yes, the
He is in
rejection order
custody,
shows.
says.
Charge sheet
He is
submitted.
in custody.
They show me as the absconder.
No, they are but the date of arrest.
He is a 439 application.
No, yes, that is there. But
All the other accused persons are absconding, so therefore he will be there for 12 years.
no, he is in custody.
He is in custody.
So, my lord, let the CD maybe.
What CD? Whatever. No.
Remanded or he has
Lateral stage, my lord.
other cases, my lord.
Your lordship may say
But
last
what about this case?
Yes.
This case, my lord,
This case, what is the year of custody? You tell me.
Year of custody, my lord, that is.
In this case, Monday, you come on Monday.
This case, I have got the instruction that he was initially arrested 2012.
In this case, what is the extent of custody? You may be in somewhere else.
My lord, they were taken to some other cases. Again, he was brought on remand on 18/6/2018. And then, my lord, commitment was made in this case on 28/6/18. Then it was transferred to the assistant session judge and waiting for, then a date was fixed to 13/2/2019 for framing of charges in this case. And 19/24, charge had not been framed because he has not been produced, my lord. Whatever it may be, in trial it will be decided, but for incarceration inside custody, my lord, they are entitled.
You tell me in this case,
my lord,
years of custody. And Tuesday, you
and the nature of allegation, again, Rasta block korthile. A poster marthile.
Naxalite.
Allegation, that is the only thing for which I have been.
But Naxalite, whatever, Naxalite or whatever.
From the code below, on the status of the case,
Because
you will give
earlier
charge was framed whether notice was issued.
Lordship may say earlier 2 orders have been passed by this honorable court in this case, specifying, calling for the records and bringing the status of the case. There has been order.
And you make sure that what you get all instructions.
Status report. If your lordship will confirm the status report from the code below, it will clarify all this.
Which is the code below? But whatever may be, 12 years is atrocious.
From the CORAM, district judge CORAM.
This is just Koraput is
assistant session judge Koraput.
This is Koraput directed to furnish a report regarding the status of which case?
City case 14/2018.
City case 14 of
2018. Pending in the court of assistant session judge.
Pending in the court of assistant session
judge.
Koraput. Release the matter next Tuesday. Same day. And in the meantime, the state council also
obtain the case
diary and inform this court regarding the number of years the present petitioner has undergone in the present proceeding.
Yes, and the date of arrest, my lord, because date of arrest, you don't
whatever, he will get this thing. And you are entitled to bail.
Yes, ma'am.
I grant bail Tuesday.
Last 5 years charge has not been framed. That is
if other accused are absconding,
other accused
segregate and proceed against him.
They have acquitted. I have given the judgment, my lord, in this bail application. They have been acquitted. Trial has been made and acquitted. Allegation is
reported same
allegation is
what is the status, my lord? Let the instruction come thereafter.
Yes, sir. Let us see. Let it come Tuesday. Yes. Well, very
May it be your as well. Let the petitioner has been charge sheeted for the offences under section 498A and 302 of the Indian Penal Code, my lord.
Yes.
Allegation as per the first information report and the forwarding report, which I have also annexed as Annexure 3, that the petitioner had got married to the deceased 11 years back.
What is the status of the trial?
It has not yet been.
My lord, that instruction is to be obtained, my lord. 1 week time may be given.
The bail plea was rejected on 3/7/2023.
My lord.
and by now is more than 1 year. What has happened?
Let pay on non-infringement after the instruction if you so want.
No, if the trial has already proceeded.
The trial has not yet been started.
Take it, sir. Next week.
My instruction.
Huh?
Initially,
State
he was
Council
forwarded.
Instruction regarding the status.
He was
quo
forwarded under
trial.
section 3.
Otherwise, if the trial has already proceeded, I will suggest you to go to the trial court to renew your bill application. To get the status. Yeah.
If not, then it can be considered.
If nothing is proceeding, then we will decide on. Yes.
21.
Lordship, item 21 on behalf of Mr. D. Naik, I seek an adjournment, Your Lordship.
You are not supposed to ask for adjournment.
Your Lordship, the client has specific instructions for my senior, Your Lordship, so that is.
What is this? This is the bail application rejected
Yes, Your Lordship.
when?
Your Lordship, rejected in 2023, Your Lordship.
23?
Your Lordship.
September,
Yes, Your
November 23.
Yes, Your
okay.
Lordship.
And now what is the stage of the trial? Do you have any idea?
Your
Do you
Lordship.
have any idea? So adjourn next week.
Much obliged, Your
Yes.
22.
Of the bail application, my lord.
Withdraw. Very
Please.
good. Withdraw. Chalo. 23.
23.
We are going very slow today. We have to reach. Yes. 23. Ankanagiri. Rejected. So we have all. What is the stage of the trial? Any idea?
Sorry.
But yesterday I asked for, he said I will go to the court and I will get all these things.
November 23, impugn order. Get next week. Seek instruction. What is the stage? You tell me. Yes. Otherwise, we will dispose it about this matter. Stage. Yes. 24. Yes. Yes, sir.
Last occasion, chemical examination was called for on 23/4/24. Marriage 7 years back, my lord. And preliminary charge sheet submitted. Whether final charge sheet has been submitted or not.
Yes, final charge sheet.
My lord, final charge sheet was not submitted due to C report. C report, I have updated that C report. That organ phosphorus group of insecticidal poison was detected.
Now, final report you are going to file.
Final report we are going.
Then you.
No, your lordship called for that whether final charge sheet has been submitted. It was
He is going
called
to,
for.
C report he has got it. He
Yes.
is going to file it. And you renew.
I am custody, my lord, more than 1 year.
That's right. But you renew
1.5 years he is in custody.
You renew your bail.
No, your lordship called for a report, my lord, whether final charge sheet has been submitted. It is filed in the year 2023, my lord.
That's right. I understand it. See, you approached the court when the preliminary charge sheet was there. Now the final charge sheet, you have to go to the court of first instance.
Case of 306, my lord. She consumed poison. I have took to her hospital, my lord.
I know. What I'm saying is something else, and you are.
Your lordship call for a report. Call this matter next week. I have to take instruction to that effect. If charge sheet submitted 306, your lordship consider, my lord.
What about what do you say? Next week.
Fine.
Next week.
Let them take instruction. I have also. That may be.
Instruction, tell me what exactly.
Yes.
25.
25, my lord. Petition or charge sheeted, my lord. 498-306, my lord. Here is the charge sheet. And kindly have glanced the relevant portion of the charge sheet.
Tell me what is this?
My lord. Yeah. I am also handing over.
You have applied for the bail.
Yes.
At the after the charge sheet is filed, have you gone to the court, trial court?
That will be again problem, my lord.
And what problem? When the court of first instance has to see it,
they will, your lordship kindly have glance the matter.
Why should I see charge sheet? See, the trial court has to see it at the first instance.
My lord, it is the practice here, my lord. Your lordship has to see this matter. Because, my lord, the matter is pending since last 6 months.
So that is the reason I'm saying. Now, in a change circumstances, the court of first instance has to look into it.
I am showing here before you, Lord.
I am not the court of first instance.
For that reason, my Lord, I am showing the change of circumstance here, my Lord. Because now bail is, my Lord, with me, my Lord. After releasing this bail, my Lord, whether I am with the conducting counsel or not, the court.
Oh, that
my Lord,
whether that is that a consideration?
For that reason,
I'll see for your satisfaction, but I'll pass the order. Which is
your
suitable
lordship,
in this case.
if your lordship not satisfied, then
But I see these are not there in the record and all.
I am handing over this record, my Lord.
Oh, so that's the problem. Everything you hand over, throw a paper on the court and you expect that it should be read.
Last occasion, if the record is with the court record also.
What do you want to say? Tell me.
I have marked, my Lord.
Tell me.
The petitioner was, my Lord, not there at the time of my Lord occurrence. May I read, my Lord, the relevant portion?
Yes.
After 1 year of marriage, her husband, mother-in-law, sister-in-law forced the deceased Rita Sodamini Manhira to bring more cash from her parent house to deposit the down payment. For down payment, they have owned a tractor for that reason. The deceased informed the matter to her brother. As per the demand, the accused persons, the complainant, given cash to the accused Shravana Manhira, present petition. On 17/9/2023, accused Shravana Manhira being left his house to purchase grocery articles for selling in his shop. On the same day at about 3 p.m., while her mother-in-law knocked the door of the deceased room and found Sodamini was lying in hanging condition by means of her sari in ceiling fan. Then they united the body deceased and laying on her bed after getting information. This is
304B.
My.
That's right.
Not a 304B. Demanding cash for repayment of tractor. Your lordship knows
all these things you are charged. What is this? I'll record all this thing and you renew your bail. I'll record it. Write down. The petitioner is agreed by the order dated 20th November 2023, passed by the trial.
Can it be adjourned?
While rejecting his bail plea. Bail plea. Meanwhile, on 1 minute, I'll give you all this. Meanwhile, on 11/1/2024, see, I'm relegating you to trial court. If they don't give you, you have to come to me only within a month. Don't worry. Thereafter, I'll give you. You have to go to the court of assistance.
Kindly pending one.
Charge sheet has been filed. Then counsel for the petitioner from the charge sheet has pointed out that at the time of the incident, the petitioner was not present at the spot. And this indeed is reflecting in the charge sheet itself. I am not inclined to entertain the present petition at this stage in view of the fact that after the charge sheet is filed, the petitioner has not applied to the trial court for grant of bail. Therefore, the petitioner goes up with the liberty to the petitioner to renew his bail application before the trial court. With this observation, petition is disposed of. I have written it. You go and you will get it. No, then you come here. But definitely, because I have written that portion, you will get it. And I'll add some more things.
36. May praise your lordship. Here is a case, my lord. The court person has been released on bail.
Yes.
It is a case of my lord holding the door, my lord committed suicide. My lord, all the independent witnesses, they have stated there is a good relationship. And how the committed.
No, my lord. Petitioner is the husband. Petitioner is the husband.
Don't
the co-accused is the father-in-law, mother-in-law.
1 minute.
Granting bail, your lordship.
1 minute, sir. Please don't give papers like this. We are following.
Bail order observation.
Because
preliminary,
you have to file everything.
Preliminary charge sheet submitted, including 302 is there, my lord. Your lordship verify the case diary.
Both the omnibus.
No, they are old aged person. That's why honorable court has.
He is husband.
If petition is the husband, man. Husband no ye. No ground.
Not the old age, that is on merit. Anticipated bail.
They are father-in-law, mother-in-law.
But
Shared
that here there is no
preliminary charge sheet submitted, my lord. Petition is the husband, my lord. There is a year mark, my lord. They are assaulted.
There is no assault physical that has been observed, my lord, while granting bail. I am custody from my lord 7/10/2023, my lord.
Bolting the doors from.
Yes, my lord. Everybody accepted. My lord, all the independent neighbor.
302 is there, my lord, in charge sheet, my lord.
6 neighbors are.
Yes.
Yes, that is the case, my lord.
He has a child, my lord, 2 years child.
That is who is
so he is the husband.
1 minute. Prosecutor has to tell.
He has a child, 2 years child, my lord. He is the present petitioner, is the husband. Why his wife has committed suicide, my lord? It is the first question.
But that is
1 minute. Let him. I am asking something.
And my lord, final
What are the evidences against him? Was the door bolted from inside?
Yes, I am reading a statement.
It is a case of 302.
Yes.
How can it be 302?
My lord, preliminary charge sheet was submitted under section 498, 302, 304. And my lord, some of their informant and sisters, they have stated that there is allegation of there is no allegation of suicide.
No, if I'm bolted inside and committed suicide, how can there be 302?
Yes. That is, I have given the statement. I am reading one.
It can't be 302. No?
I am reading one charge sheet, whether it was
No,
submitted or not.
you lordship, he has not. You lordship.
Next week, clear.
And my lord,
Next week, you develop patience. Next 1 week will be enough for developing patience. Next 20.
Final charge sheet में
20.
कितना time लेनी 20 final charge sheet time लेना थी
Wait, sir. You are not allowing the prosecutor to tell. You keep on saying there is a objection. Please wait next week.
बहुत सारा time लेने तो
Because of you.
नहीं seven time no सुन.
Because of you. Because of you. You must understand. Yes. Yes, sir. No appearance. I will put appearance. All the there won't be any problem for lawyer. Yes. 28.
Item 28.
Yes, sir.
I pray for next week. In the meantime, the material witness, only one witness is examined. I'll produce the deposition copy.
Then you apply. Material witness is
today I have already got the deposition copy. You'll have to keep it next week.
Material. Who is the material witness?
Only Devlal Satnami, my lord.
Huh?
Devlal Satnami.
Or Devla Satnami. Right. Petitioner is agreed by the
No,
order
may I
dated
let's
18/10/2023.
keep it next week any day.
1/18/2023, whereby his bail application has been turned down by the court below. Court below. The first court below. Because the petitioner submits that in the meantime, material witnesses have already been examined. In view of the changing circumstances and the fact that the material witnesses have been examined, the petitioner should approach the court of first instance for grant of bail. Therefore, I am not inclined to entertain this petition. However, granting liberty to the petitioner to move the trial court, for grant of bail. If such bail application is moved, the same shall be considered on its own merit. You go there.
Miller.
October se pending or 1 year, 2 year, these applications you revive. Yes. Next. 30. 29 over.
29
in progress. 30.
Item 30. My lord.
Yes.
My lord, in this case, my lord, I have filed a IA for interim bail, my lord. Petitioner is the only son, my lord, and his father is his kidney is damaged, my lord. Left side kidney and his
father.
Yes, my lord. He need dialysis or
what about the main prayer bail?
Main prayer present petitioner, my lord, went to the house of the informant, assaulted him, my lord. When her wife came to rescue his husband, my lord, he has fired on her and died on the spot, my lord.
Died?
Yes, sister. Wife of the informant died at the spot, my lord. Gunshot injury.
Gunshot injury.
My lord.
Interim bail, just see. Whatever he said.
Just now I have received I will obtain the instruction, my lord. Only. His ground, my lord, interim bail, my lord. Ground is renal failure, my lord.
The father has it.
I will obtain the instruction.
Interim bail for the counsel for the petitioner submits that the father of the deceased, he is the only son, and his father is suffering from renal failure.
Kidney failure.
Kidney failure. Kidney failure.
Kidney failure. And he has filed certain medical document to support his case. And counsel for the state shall seek instruction regarding the same. Leave the matter next week.
My lord, IA is not tagged with original file, my lord.
Next to get hoga ticket asibo to instruction.
2 week for me.
1 week after.
1 week after. Yes. Next 31.
IA number 922/2024 maybe.
IA number
922/2024.
IA number 922.
Maybe tag, my lord.
Yes.
Please.
31. 31. Withdraw. 31 withdraw. Yes.
Permitted to withdraw, my lord, item number 31 and item number 48. This matter also kindly permitted to withdraw. 48.
48, 31. Withdraw. Okay. Yes. 32.
Item 30. For cancellation of bail, kindly have a glance of page 22.
What cancellation? People are struggling to get bail. You are asking for cancellation.
For a moment, my lord.
What is the offense?
302, my lords. Kindly have a glance, my lords.
When the bail was granted?
Bail was granted on 12/11/2021, my lords.
Why 21 the bail was granted? Now you are seeking, what are the grounds?
Grounds is that he has been continuously indulging that criminal activities, and in the meantime, the NBW has been issued by the lower court.
NBW issued in some other case?
Yes, in this case only.
He is not appearing.
He is not appearing, my lords. Kindly have a glance. Page 90.
19, 19.
For the order sheet of the lower. Page 19.
This is the difficulty. We are paperless court. You are giving the papers. What will I do with this paper? How will I read it?
Yes.
Even if we read it, where will I keep it?
Yes, ma'am.
There should be some file.
Yes,
there is no file. So therefore, you are supposed to file all this, so it will come on record. Suppose I rely and pass an order.
Yes, ma'am.
Tomorrow that will not be there on the record. The other side will go and complain because he has relied upon something which is not.
I will in the course of the day, my lords. But may move for a
First
moment.
of all, satisfy me that it needs to be considered. 2019, this matter is pending.
Page 19, my lords. Page 19 of that order sheet, my lords.
19.
19. He has been continuously absent, my lords. The accused person are absent. NBW issued against the accused person. Order dated 13/5/2021.
Who had granted the bail?
Yes, ma'am. Coordinate bench of this honorable court.
Show me bail order.
Page 17, my lords.
17.
Aye.
Yes.
The appropriate portion is at page 22, my lords.
Yes. What are the conditions?
They shall not indulge themselves in any criminal activities. They shall not influence, threaten, browbeat or pressurize any witness. They shall cooperate with the learned trial court for early disposal of the trial. They shall appear before the learned trial court on each date when the case will be posted for trial. The inspector in charge of Boromba police station shall keep a vigil over the activities.
Notice has not been issued in this matter.
No, ma'am.
Huh?
No, ma'am.
And then move to the trial court. NBW has been issued. And the trial court will consider without being influenced by.
After this, my lords, there has been 2 more cases that has been added as a party. I have given that FR, my lords. How did the cases go to FR attached with more petition, my lords, page 28. Tapore I would the 24 I would be FR exam.
Then you move after trial court for cancellation of bail, whatever. And I will observe that without being influenced by the fact that this court has granted bail, the court will independently apply mine and decide the application.
Yes, ma'am.
Because all these facts you can bring.
Yes, my lords.
Independently, let the trial court write down. The petitioner is in this petition is seeking cancellation of bail granted by this court by order dated.
In this case, NBW already issued, that means the
I know that.
Relevant ballot permitted.
I know that once he will not cancel it. He'll take into custody. That I guess. Yes. I know. To the opposite party number 2 by order dated 12/11/2022. This court while granting bail to the opposite party number 2. How many?
One minute.
Opposite party number 1, huh?
Yes.
Sure.
Yes, one.
Opposite party number 1 had imposed the following conditions. What are the conditions?
Page 22 minutes.
Page 22. Let counsel for the petitioner submits that despite these conditions, the opposite party number 1 has been misusing the concession of bail granted by this court. Therefore, on where is that way? 19, page 19. On 11/3/2024, the trial court has issued NBW against the opposite party number 2, opposite party number 1 for consistent absence from the trial court. Apart from that, the petitioner, the opposite party number 2 is also involved in two more cases.
One is page 28 minutes.
2 more cases after the bail was granted by this court. Hence, he seeks indulgence of the court for recalling the concession of bail granted to the petitioner. I am not inclined to entertain this petition. However, I grant liberty to the petitioner to move to the trial court move to the trial court for the said cause. If any such application is filed and supported with material, the trial court should independently assess the matter and pass necessary order without being influenced by the fact that this court has granted the bail to the petitioner. With this observation, the petitioner.
Milord.
Yes. Next.
This is a minor defect. I will remove it by Monday. Lordship, kindly take up this matter for admission.
Ignore the defect. Tell me the merit.
Yes. Milord, here the petitioners have challenged the order taking cognizance as well as the entire criminal proceeding. What has happened, Milord? Milord, there is a civil
That order was passed on 4/2/2020.
Yes, Milord.
What has happened now?
Now trial has not commenced as a
Charge might have been framed.
that instruction I don't have. But
Obviously, 4 years. Yes, Mr. Raghunath.
I'm taking instruction as because this is the second date, my lord. First, earlier matter urgent, my lord. After vacation.
No, see, this is a matter pending since last 2 years.
My lord.
About 2 years, 1 year. 1 year. And he's challenging the order dated.
I've also prayed for questioning of the entire criminal proceeding.
Well, that's right. 4/2/2020, the cognizance is taken.
Yes.
And by now, charge everything might have been framed. And you have other remedies.
But, I'll take
If charge not
instruction.
framed, we can raise all this point at
That's right.
time of framing charge.
But if the charge has already been framed, trial is going on, then he has no clue.
For that, I would take instruction whether charge framed.
You tell me, your petition, you tell me whether charge has been framed.
I'll take instruction. I have not taken instruction.
I don't know why these cases are unnecessary pending.
If charge not framed, then liberty.
I'll tell you one thing. If charge is not framed, you raise all these points before that
So
court.
kindly
If charge
appreciate.
is framed, you have other remedy to.
Appreciate for a moment, Milord. That she was assaulted. 307 has been, police has registered the case and filed a charge sheet. Out of
Against the father.
No, against the petitioners. Petitioners are all family members of one family. They have filed a civil suit against the opposite parties, and injunction order has been passed.
And they have completely false case, my lord. Witness, two co-villagers have filed affidavits that they don't have any knowledge about the occurrence.
So all these things will be tested in the trial.
Because, my lord,
very fact that why, what was the necessity to get the affidavit?
My lord,
Who has got it? You might have got it.
Yes,
Then you are collecting evidence now.
No, my lord, because they are the co-villagers.
That's why have you got the affidavit from them?
To show that it's a completely false
No,
case.
you are
My lord,
putting
my
evidence-
grievance is the petition
evidence
number 5 is a student. He is trying to
said anything against you, then you have to face it.
ମୁଁ ଆଜି ତା 20/4/19 ପରେ ପୋଲିସ ନିକଟରେ this is the mother ଜମାନମଦି
Injured witness.
Injured is the according to injured report, the daughter is the injured. Simple injury.
What is her statement? Because all other witnesses have said something or the other something, some allegation or the other against you.
That doctor's statement is not there probably.
That's the only thing I have to see. The injured. That is the basis. The main thing you don't find that I have been searching.
I have filed a complaint.
And all other witnesses have said against you.
As you copy paste statement.
But the copy paste what?
All lines and every daughter says I was raped by the same accused person at the same time. Mother says I was assaulted.
See, in one side there are circumstances which are in your favor. In the other side there are evidences.
That is.
And for a cognizance court, what is important? He will analyze the circumstances or he will see the evidence.
Your lordship can analyze.
No, I can't. At cognizance, I am also exercising that power only. I can't analyze the circumstances and give benefit of doubt and acquit you by quashing proceeding. I can't do that. You know more than anyone else.
Noticed at least.
No, better I'll tell you. Better you argue all this point before the trial court. I'm giving you that liberty to argue all this point.
All right.
The petitioner is agreed by the order dated 4/4/2020. 4/2/2020. Passed by the learned additional sessions judge come assistant sessions judge Kendrapada in ST case number 211 of 2022, whereby the trial court has taken cognizance for offences punishable under section 4. Okay. The learned counsel for the petitioner has taken me to various documents to substantiate his stand that the case is completely false. I have perused the statement of witnesses under 151 CRPC. And I'm of the considered view that at this stage, this court, the petitioner, I am of the considered view that the petitioner is not entitled to any indulgence at this stage. However, the petitioner has the liberty to argue all these points before the trial court at the stage of at the appropriate stage. And there are a bail remedy under law. With this observation, the petition is disposed of. Yes, next.
34.
May please. The defects, I have removed the defect number 6 because I have given the copy. And regarding defect number 19, let's say kindly be ignored because that is for undertaking.
Yes, tell me on merits.
Let's say in this matter, let's say there is a misconceiving allegation against the petitioner regarding a Facebook post, while the seized mobile doesn't belong to the petitioner.
Yes.
And that is why I have challenged this proceeding, Your Lordship. Which a cognizance report is
Cognizance has been
order.
taken.
Yes, Lordship. While the said mobile is not seized from the petitioner, still the court has taken the cognizance. And he is a senior citizen and it is a
Now, what are the
God-fearing-
allegations against him?
Only
Serious matter.
her Facebook post.
Regarding the Hindu teach my lord.
No,
ରବୀନ୍ଦ୍ର ମହାନ୍ତି ନାମଧାରୀ ବ୍ୟକ୍ତି ଜଣେ କି
Only
ହିନ୍ଦୁ
saying
ମାନଙ୍କର
that-
ଧର୍ମୀୟ ଭାବନାକୁ ଆଘାତ ଦେଲା
Only
ପରି
one
କହି
post.
ପୋଷ୍ଟ କରିଛନ୍ତି। ସେ ଦେଖିଛନ୍ତି ହିନ୍ଦୁ ଧର୍ମର ଦେବତାଙ୍କ ଦ୍ୱାରା ଧର୍ଷଣ ଜନିତ ଘଟଣା ରହିଛି, ତେଣୁ ସେ ଧର୍ମର ଅନୁଗାମୀ ମାନେ ଧର୍ଷଣର ଅନୁଗାମୀ। ଏବେ ଧର୍ଷଣକାରୀ ମାନେ ସୁଗନ୍ଧିତ ଫୁଲମାଳ ଦ୍ୱାରା ଅଭିନନ୍ଦନ ଜଣାଉଛନ୍ତି। ଏହିପରି ଆଉ ଏକ ପୋଷ୍ଟରେ ହିନ୍ଦୁର କୌଣସି ଧର୍ମ ନୁହେଁ, ହିନ୍ଦୁ ଧର୍ମ ଅତ୍ୟନ୍ତ ଉଗ୍ର ପ୍ରକୃତିର ମାନବତାର ଚରମ ଶତ୍ରୁ ବୋଲି ଲେଖିଛନ୍ତି। ଏହି ବର୍ଷ ପୋଷ୍ଟ ମାନେ ହିନ୍ଦୁ
But that mobile is not
Right.
of the petitioner. And
You might have used somebody's mobile also.
No, Your Lordship, he is a very God-fearing person and he is very famous in that locality.
God-fearing like this.
The temple, he has made so many temples in Baleswar, Your Lordship, kindly.
Thereafter
That
he
is the
is
fact. That is the fact. And I also, Your Lordship, I have cited one judgment at
Are you
his
on bail?
court.
What the
Same.
charge is?
During course of investigation, examining complaint, other witnesses and recorded their statements. 161 CRPC, Oppo Reno mobile phone.
That 1, 2, 5,
Yes.
7. That 1, 2, 5,
Yes.
7, 8, 9. Yes, Lordship. From possession of the complainant, it was seized. What the complainant had said, that is in that mobile.
अपलोडेड जोड़ा है तो सीधा कंप्लेंट ये रूम सीज करा लो।
Complainant.
जो रविंद्र महांती अपलोड करते हैं से
रविंद्र महांती Your Lordship. Your Lordship.
मोबाइल सीज चलाई
No.
अपलोड करते हैं।
ना सिर्फ है ही नहीं।
करा ला दिखाई दे रहा।
From the Facebook authority, seized one Realme mobile phone from the possession of the alleged, but that was not written whether that.
And what happened is, this gentleman has posted something in Facebook.
Uploaded,
and the complainant in his mobile saw it.
Exactly.
And he has given it to the police.
Exactly.
And from there it was printout was taken. Obviously that will be his mobile.
But that is not.
That is what is the case is.
That actually.
Suppose you post something. I want to see it in my mobile. I have seen.
Yes,
it.
I understand.
And I gave it a complaint to the police.
Yes,
Police
yes.
will take my mobile.
Yes,
From there,
yes,
printout was taken.
I understand, but the fact is that this is not this petitioner's post, Lordship.
How will I know?
Because this
another
number
thing,
is-
after execution proper Jimanama, sent requisition to SP Bhadrak to obtain information and detail of the user Facebook ID. Rabindran Mahanti, Bhai, your number such and such, Facebook such and such, from Facebook authority. One Remil mobile phone such and such.
Seized.
And Mahanti were in presence of witnesses. The prime has evidence under section 5052 IPC and 16 of IT Act.
Same no, Your Lordship, kindly have the same sentence. That what my learned friend.
And I serve notice on 41 to Rabindra Mahanti, Sri Prabhas Chandra Pal, supervised the case, and Kurtibasa Mahanti, such and such. Nothing is written. He has not complied also the 41, my lord. Report against the Rabindra Mahanti as there is prima facie evidence under section 5052 IPC 67 IT Act. Well made out with prayer.
From what it was made out that prima facie, that is the evidence. From what?
Evidence is about there. One system statement there
only
also.
that sentence, Lordship, what my learned friend is saying, that the obtaining information and details from the possession of the complainant Harapriya Sahu in presence of witnesses. Full stop. Left the seized mobile such and such to the complainant after executing proper Jimanaba, it was returned. Send requisition to SP Bhadrak for obtaining information and details of the user Facebook ID Rabindra Mahanti by URL number such and such from Facebook authority. Full stop. Tapare hela seized one Realme mobile and from possession of the alleged
Facebook authority has to give the report.
No. That there is a full stop after Facebook authority.
Full stop.
So Facebook authority.
It was sent to SP for ascertaining the
correctness of.
User ID and
Yes,
user
yes.
ID of Facebook.
Yes,
User ID of this
yes,
gentleman.
yes.
It was sent, and he has sent it to the Facebook authority.
Yes,
And
after
face-
that.
No, no,
Facebook people
no,
will give.
One there, my lord.
That
Man, one
no,
minute.
that's
One seized one real mail mobile phone having EMI number such and
Number.
such
SIM number such and such.
and such and such
From
the possession of alleged Ravindra Mahanti. In
Huh.
presence of
No.
witnesses.
No, mobile siege with this number. But let's say my point is from this number, that phone, the Facebook, that post is not.
That is the subject.
No,
matter.
So that,
no, no,
that has
no,
been
no.
looked into by the
No, no,
court. You
let's
can't, presume everything here.
No, let's say only one point what my learned friend is showing that mobile is seized and the SP was directed. These are
SP
correct.
is seeking information from
the Facebook
Facebook.
authority.
Let it
But-
come.
Yes.
How do you know?
But because this number.
If it doesn't come, then you are out.
That is my point, your lordship. Without going into this, how the cognizance was made against me.
So argue all this.
This,
20 stage of-
mobile also
No,
seized
your
from
lordship,
him.
your lordship.
Where-
I will satisfy your lordship. Only your lordship make.
No certificate. I am
Your
giving you
lordship,
liberty. I am giving
Your
liberty
lordship,
to argue all this
kindly-
point at this stage.
Kindly have a glance at page 4. I rely on this judgment of Supreme
Yes, yes.
Court.
4.
Yes,
Come to
page 4, para 5.
Page 4.
Yes,
Come to
para 5, your lordship.
para 5.
Yes, lordship.
Yes. Yes.
Under section, may I submit that?
Yes, of course.
Under section 505 subsection 2, promotion of such feelings should have been done by making a publication or circulating any statement or report containing rumor or alarming news. Mensia was held to be a necessary ingredient for the offense under section 153A.
That's right.
And but no mensia is proved here. That is my point. Only whatever she is saying, that was given the importance.
That's
and,
the mensaria.
But
Their
my-
intention
the common
is to
factor-
hurt people. That's the mensaria, or what else?
The common factor of both the section being promotion of feelings
These are
of
general
enmity.
general principle of law.
That is feeling of enmity
Yes,
and
they-
hatred. But it is very.
That's what
that
allegation is, enmity, hatred against Hindu religion. You are
No, actually-
creating all this. These are the mensaria. What else?
No, your lordship. I may be
No,
pardoned,
no,
lordship.
not make no.
I may be pardoned.
You have
I will
argued so
satisfy.
well.
I will satisfy. Your lordship may call it any day, your lordship. I will satisfy. I will satisfy on this point.
So far you have not satisfied. What will you do?
I will satisfy. your lordship.
For your satisfaction, I will keep it till Monday.
Monday.
Monday. No, because I'm fully convinced. For one thing, that cognizance is rightly taken. You can get an opportunity to argue all this point. The nitty-gritty, mensaria, whatever issue you are arguing, you argue. With this observation, the petition is disposed of. Yes. Move an application.
Yes,
You
lordship.
will be discharged.
At page 26, lordship, cognizance of the offense under section 505 IPC.
505
Huh.
and 67.
Yes.
Both 67 also.
Yes.
505 and 67. They can be lost.
Okay.
Yes.
Okay.
May it please, my lord. Lordship, I mean DC, my lord.
Yes.
Lordship, the important order arises out of a proceeding and under the PW Domestic Violence Act, my lord.
Yes.
This is a surprising order, Lordship, because the learned court below allowed the applicant for amendment of the evidence, Lordship. Had it been a matter of complaint petition, then the matter would have been different, Lordship. But the evidence affidavit was filed, subsequently it was recorded, and thereafter the defendant filed an affidavit before the learned court below. Yes, I have filed that evidence affidavit. Some clerical errors were there, so let the evidence be amended. And that was allowed by the learned court below, my lord.
Oh, that's typographical error can be corrected. What is wrong in
That
it?
cannot be an evidence, Lordship. Had it been a matter of complaint petition, then the evidence was already recorded, and subsequently he filed an application.
Evidence by way of affidavit.
Yes, Lordship. Kindly have a glance to the application filed by the applicant at page 5, Lordship.
What are the changes? You show me what are the changes? What are the amendments there?
Date of birth of the child, Lordship.
Is it prejudicial to you, or just simply for technical ground you are?
No, first of all, it is no doubt. She has filed the birth certificate.
Show me what are the changes she is seeking.
Just only the date of birth of the child, Lordship.
Your child, what is the problem?
No problem is there, Lordship. Even if she has filed the birth certificate of that child, I am not going to that aspect, Lordship. But on a technical ground, I am submitting before Lordship the.
No, forget it. If it is prejudicial, you tell me, I'll interfere.
No, because
if it
the
is not
date of birth
prejudicial,
is-
don't bring technical issues in matrimonial dispute.
No, not
She might have given the date of birth of your child, a wrong date. She wants to correct it. What is the big deal about it, and what prejudice has caused to you?
No, Lordship,
Merely
because
you are unnecessary multiplying the litigation.
no, my lord, I am not at all multiplying the litigation.
This is a frivolous litigation then.
No, my lords. Kindly have a glance to the para 5, page 5, para 1, my lord.
Yes.
She has filed the birth certificate of that child. I am not at all disputing the same because the
Tell me one thing. You tell me one thing. This child is your child or son?
Yes, my lord. Absolutely. Yes, my lord.
Still you have a problem.
No, I don't have any problem. Because the order that has been passed by the learned court bill, I am just challenging it. Because an evidence cannot be challenged, amended, my lord.
Maybe you are correct. On a legal proposition, you are correct. But since it is not prejudicial to you, it is a matrimonial dispute, I am not going to entertain this.
Yes, I am confined to that legal principle, Lordship. I am not.
I'll record your submission. I'll say that technically or legally you are correct, but I will not interfere because it is not prejudicial to you. Okay? That much I can do.
My humble submission before the Lordship is there. Lordship, 1 minute. Kindly bear me for 1 minute, Lordship. She has annexed the birth certificate.
I completely agree with you. Yeah, I disagree, then tell me. I completely agree with you.
Yes, Lordship, but the
100% agree with you, but I'll not give you relief because it is a matrimonial dispute. Only the date of birth of your son.
Child, yes, daughter,
written by your wife wrongly.
Yes, my lord. I am not.
And the fact that she has filed the birth certificate also is also reflecting. So then,
Yes, birth certificate is there. Let the date of birth, correct date of birth we recorded. It is there, but the order that is passed by the learned court bill, that is wrong.
I'll write that.
Yes, ma'am.
The petitioner is the husband of the opposite party. The petitioner is agreed by an order dated 24/7/2023 passed by Learned JMFC Bhubaneswar in CMC number 596 of 2018. It appears the opposite party has filed evidence by way of affidavit. In the said affidavit, the date of birth of the son of the parties, son of the petitioner was wrongly mentioned. Therefore, she moved an application for amendment to the affidavit, which has been allowed by the trial court in relevant to mention that along with the affidavit, the petitioner, the opposite party had also filed the date of birth certificate of her son. That counsel for the petitioner has assailed his order on sheer technical ground. The counsel for the petitioner submits that evidence cannot be amended. Evidence cannot be amended. However, the trial court has allowed the opposite party to amend the evidence, amend the affidavit filed by way of evidence. Technically speaking, the petitioner may be correct. However, since it is not a prejudicial order, I am not inclined to interfere in this matter. Moreover, this is a dispute arising out of a matrimonial discord, and petitioner is the wife, husband of the opposite party, opposite party. And it is the correction is sought regarding the date of birth of their son or daughter?
Daughter, ma'am.
Their daughter. Therefore, according to me, the petitioner is not prejudiced by the amendment sought and allowed by the court below. Hence, I am not inclined to entertain this petition, and the petition is dismissed. Yes. Next.
Lordship is dictated in the first para, that is son, that may be daughter, my lord, in the first para.
Daughter.
Item number 36.
Yes.
My lord, kindly 1 week time for remove
Why?
the
You tell me what is his case?
remove the defect.
So 2023 is pending. Tell me what are, let us see if required, I'll adjourn it, but let us see what is this order. What is this petition? 8/9/2023, Annexure 5. Where is that? What happened? Annexure 5. What happened by this impugn order? Oh, maintenance of 5,000. You got it. What are you doing? What are you doing for living? You are the husband. Who are you, sir? You are the husband of the opposite party number 1 and father of opposite party number 2.
Badaljan.
Father of opposite party number 2. 5,000. Daughter and wife. 5,000 also will not give. In today's scenario, 5,000 is just nothing. What are you? You are working as what? In a DB proceeding, it was per month. Come tomorrow. I will not interfere. Come tomorrow. Tomorrow. I will not interfere because you have not prepared, therefore I am giving you. I will not interfere. In 5,000 maintenance is nothing. Yes. Please, please ask what this petitioner is doing. What is his income and all. Please get that thing started. Yes.
Take care of it.
Sorry, one.
I thought 37 and next week.
Don't ask adjournment, sir. Tell me you have not cured the defect 6, 15, 18, and this matter is pending since 2000. Okay. When you filed? This you have filed 16/11/2023. Defects are not cured. Why have you not done it? What are the defects?
Of the year 2002, man.
Passing.
No, man, passing. Yes, challenges 3 orders. First, 3 orders you have challenged. First is cognizance order 2/1/2004 cognizance order. Then 12/10/2022 charge was framed. Then 15/9/2023 summon issued to the witnesses.
All
Three
the
orders
orders
he has
in one. So therefore the defects.
And the offense is under section 225 to 24.
And this petition is filed on 16/11/2023, challenging 3 different orders passed by the court below. In fact, the petitioner ought to have resort to separate remedy for each of the impugn order, each of the impugn order. Be that as it may, the registry had pointed out various defects which has not been cured by the petitioner. If the defects pointed out by the registry not cured by tomorrow, the petition stands dismissed without the court. Without a constitution, if defect is shown, this will not have Tuesday. 38.
For offense under section 307, 325, 385.
Yes.
Passing of a fairman. Earlier, my lord, they have all
filed.
Anticipatory, they have filed. It was rejected. All that it was.
Charge sheet?
This is yes, charge sheet. Receipt copy has not annexed.
File or not? Mini file.
19/1/23.
32307.
307. 307, 385.
Investigation over or not? You tell me.
I will check. After launch.
After lunch, pass over. You simply say, I'll dismiss it.
Madam?
I'll dismiss it if you,
Madam, I
if
will
the
pass.
charge sheet is not filed, then after filing, they will. Yes.
39.
Trying to remove the defect.
What are the defects? Ignorable or?
My lord, defect is that 144 proceeding was initiated by OP number 2 and 3. That was after a lapse of 60 days, it was top. Again, that petition OP number 2 and 3, they have again filed 144 proceeding initiated. But only notice was, he has annexed only notice. That whether that land in which earlier 144 was.
23, you have filed this on November 2023. By now, that proceeding is also might have been over.
And my lord, date
Nothing
was.
survives in the application.
And date was my lord 17/10/23 to appear.
Although your client might have appeared and everything might have happened. And even if any order is passed, the life of that order is 6 months.
So that if order has been passed, that also.
That also might have been over. Right on. Petition is agreed by the proceeding initiated by the opposite party number 2, na?
2 and 3.
Opposite party number
2 and 3.
2 and 3 under section 144
CRPC.
144 CRPC.
In
The
CFC number.
proceeding was initiated way back in 2023 and the notices were issued on
Notice was issued on 19/9/2023.
19/9/2023. 23. The order passed by the executive magistrate, na?
Sub collector from ST.
The sub-collector.
Sub-divisional magistrate.
The order passed by the sub-divisional magistrate come sub-collector. In a proceeding under section 144 CRPC.
In CFC, no.
Life of an order passed by a executive magistrate. The orders are passed.
But by the sub-divisional magistrate.
Sub-divisional magistrate remain effective only for 6 months. Only for 6 months. Since notice was issued way back on
19/9/2023.
19/9/2023, and the petitioner, the present petition is pending since 10/11/2023. 23. I am of the considered view that nothing survives in the present petition. Therefore, the petition is disposed of with the liberty to the petitioner to approach this court if cause of action still survives.
And my lord, only that in CMC that number may be my lord reflected. 144 proceeding in CMC number 121 or 23.
121.
CMC number 121 or 23.
144 proceeding in CMC number
121.
Yes.
40.
40 and 41, my lord. 40 and 41, my lord. Can take tomorrow, my lord. Mr. Molia has not come, my lord.
No, tomorrow, you according to your choice, I can't see. We are how many matters are listed today?
40.
63 matters.
40 and
We are
my lord.
item
My
40.
lord, he is suffering from fever, my lord.
138 proceeding. You are accused.
Is that
Seeking causing.
No, no. That 143A petition was allowed. That interim compensation.
That's the law.
Check amount is 8,92,000, and he is directed to pay 1,33,000, 20%. And subsequently file a revision. Revision was dismissed. So he has to pay that.
You have no.
Tomorrow, my lord.
No, tomorrow.
My lord,
No, tomorrow.
my lord, he has to
I
come.
pass it over. You come at 2 o'clock. I will only do one thing, that I can give you a chance of applying to the trial court for the installment. If you can't pay, pay in installment. To that extent, that indulgence I can give you. Beyond that, I can't. You can't pay. You can apply to the trial court for paying it in the installment basis.
That order was passed in 2022.
But he may not have that kind of money. Some installment, something you do. Little leverage,
23 division was also dismissed in the year.
You have very bad case, so therefore think of paying it on installment basis. You apply to the trial court for
installment.
Pass the order right now. I'll pass the order. Both the matters?
Both the matter.
41 also same, my lord.
Right.
41
Both
to
matters, 41 here for the petitioner is aggrieved by the order dated first order dated 16/9/2022. 16/9/2022 passed by the JMFC Salipur in 1 CC case number. Petitioner is agreed by the state order. Agreed by the sir. I am not inclined to interfere in this matter. In the amount on installment basis. If such application is moved, the same shall be considered on its own merit. With this observation, the petition is disposed of. Next, 43.
My lord.
41 also same, man. Same accusation.
Same accusation, but here you said revision and all. 40. This is 41 over 42.
No.
42, my lord. 42, the matter has been amicably settled. So your lordship may kindly give me 10 days time. I'll bring all the parties before your lordship. Item 42.
Passed order in 41 same order. 41.
41 also same. I'm passing the order. I will record your statement. 41.
No, my lord. 42. I am for 42, my lord.
My lord,
Okay.
42 matter has been amicably settled.
1 minute. Let me complete. I got confused. 41.
41 same, man.
1 minute. 41 will be same, H?
Same.
Same. Yeah, 41 same. Yes, 42. What
My lord,
you are saying?
Matter has been amicably settled. Your lordship give me 10 days time. I'll bring all the parties.
Mr. Asutosh Mishra, Land Counsel for the petitioner, submits that matter has already been settled. What is this matter is about? Why,
my lord, the matter is that I am a licensed labor interstate migrant.
No. What are the offences? Settlement.
Offences, your lordship, that is 370, 374, 420 of the IPC.
Compoundable.
No, not compoundable. If had it been not compoundable. But the offences, very less amount of penalty is there.
But you are asking for quashing.
Yes, your lordship. Because the all the victims I'll bring before your lordship, they will file affidavit. Your lordship may give me only 10 days time.
So I will not say anything. You just simply adjourning.
Yes, your lordship.
If it is a settlement thing, then state has to say something.
Let it come 10 days after.
Whatever affidavits for the informant, whoever are there,
my lord,
please file and record and give a copy, supply.
Prior copies. Your lordship may
examine it. Can it be done or can't?
Your lordship may call it 10 days
record
after.
Record it like this.
My lord.
Mr. Asutosh Mishra, Land Counsel for the petitioner, submits that the parties to this dispute have already settled. He wants to place on record the affidavits of the parties to press this petition for quashing. Let the petitioner file the appropriate affidavit and supply the copy of the same to the State Council, and the State Council shall seek instruction in this matter, and the matter shall be decided on its own merit, taking into consideration the fact that the parties have settled their dispute. With this observation, dispute, please the matter on certain has taken. After 1 week, 2 weeks.
41 same order hela.
Your lordship may call it on 14th, my lord.
Amount 130, it's only 30,000.
Your lordship may call it on
14th. I am giving after 2.
Item 43. Item 43.
You don't have any strength, I think. You have lunch and come. You're so slowly speaking, you have your lunch and come. 1 minute. Huh? 38. 38. Yes.
There is to cost it. Directed to make instruction. What is the oral instruction taken from the IS that is said that preliminary charge sheet has already been filed. And the final charge sheet will be filed because they have put the record.
Charge sheet has the preliminary charge sheet and is anticipated will rejected. Anticipated will rejected. Right now, the petitioner is seeking quashing of the FIR number so. That counsel for the state submits that in the present case, the preliminary charge sheet has been filed after the present petition is filed by the petition, filed by the petitioner, and the filing of the final draft is awaiting. I am not inclined to entertain this petition at this stage since the investigation is still on. However, liberty is granted to the petitioner to revive his prayer for quashing. Liberty is granted to the petitioner to restore to the remedy available to him under law at appropriate stage. Yes.
43.
Yes, please put that.
43.
43.
Cognizance order, my lord, 24/12/19. Quashing of cognizance.
Where is that?
Nobody is there.
What, 43? Cognizance?
Cognizance, my lord. Dated 24/12/19, my lord.
Yes.
And charge sheet has been submitted. Prime facie case will made out against the petitions, my lord. And order dated 24/12/19, page 34.
Non-APS what to do? This file in November 2000.
My lord.
23. Charge sheet has been filed.
Charge sheet
Cognizance
cognizance
is taken.
my lord.
And
Prime facie will made out.
Made out. So non-APS dismiss for non-prosecution. If he is interested, he'll come.
My lord.
We'll move application, we'll see. Yes.
44.
May I please, your lords? The case under section 138 NI Act, my lord, I am challenging the order taking cognizance, my lord. In the meantime, my lord, since the prosecution evidence already, my lord, cover, my lord, so I may be allowed to 245 discharge application file before the trial court.
Lord counsel for the petitioner seeks to withdraw this petition to avail remedy under
245 CRPC.
Under section 245 CRPC. The present petition is dismissed as withdrawn with liberty as spread.
And the magistrate may consider, my lord.
Obviously.
Lordship may indicate.
You move application, magistrate will not consider.
Yes, my lordship. One observation.
Magistrate obviously will consider. You move an application, will not consider. You took the liberty of moving an application. Once you move application, right, wrong, whatever, he has to pass an order.
In accordance with the law, lordship.
If such application is moved, the same shall be considered on its own merit. Okay. These observations are neither here nor there. Yes,
45 same, my lord. Same order.
40?
45.
45 also.
Same order.
Same. Yes.
46.
Lordship, on behalf of Mr. Chau, this is a release of vehicle, my lord. That's petitioner is the accused and owner of the vehicle.
Your application under section 457 is rejected?
Yes, my lord.
Okay. Where is the order? Rejecting?
Order at my lord. Annex 3, page 21.
Confiscation proceeding? Yes. Confiscation proceeding is initiated. Is there any proceeding pending under section 60 or 52, whatever?
We'll take instruction in the.
The petitioner is agreed by the order dated 12/11/2021, whereby his application under section 457 CRPC for release of the vehicle involved in the crime has been rejected. Issue notice to the state to seek instruction regarding the seek instruction regarding the confiscation proceeding, if any, initiated by the prosecution or not, at least up to 2 weeks. Yes.
No blessing.
2 weeks. 2 weeks.
47.
Infructuous.
43 also, my lord, infructuous. Sorry, I am not there when the matter is
Thank you.
called for.
43
Non-absent. There is non-absent dismiss here, let's say.
Oh, infructuous. 43 infructuous. Yeah? No.
43.
43 infructuous and 47 also infructuous. Yes.
Okay.
48 withdraw. Yes.
49.
Yes.
Application has been filed for extension to deposit the amount.
What amount?
The appellant was convicted under 138 of NI Act. Subsequently, he had to pay 20% of the amount. For that extension, we have filed. The Lordship had allowed him before as a last chance. Due to financial activity, we could not.
Time is extended up till 15th May.
Yes, Lord.
2024.
Yes, Lord.
We are in July.
Yes, Lord.
Once it is extended, May.
Yes, Lord.
Again, you are asking for extension.
Due to some financial difficulty, he could not pay in the time. Now he has arranged the money. He will pay the amount.
Huh?
He will pay the amount. He has arranged the money. Due to some financial action, we could not deposit at the stipulated time.
How much time you need?
1
week.
days. 1 week.
1 week.
Yes, sir.
By the order dated 2/4/2024, the petitioner was granted time up till 15/4/2024 to deposit 20% of the check amount, that is 70,000.
Yes, sir.
That is 70,000. He sought extension of the time. Therefore, this court further extended the time up till 15/5/2024 to make good the payment. A third attempt is being made this time, seeking further extension. By way of last and final opportunity, 1 week time is granted to the petitioner to deposit the amount as directed by this court,
Yes.
as directed by this court by the order dated 2/4/2020. By order dated.
It was ordered in 2/4/2024.
19/2/2024. 19/2/2024.
Then it was modified.
And 2/4/2024. It is made clear that no further extension shall be granted to the petitioner.
Obliged.
50.
Petitioner pays for modification of the order dated 67/24 to extend the time to surrender. Last time my lord was pleased to modify the order, but no time was extended.
For the reasons stated in the application for seeking extension of time, the same is allowed. Petitioner is directed to appear surrender before the court below on or before 20th of August. 20th August, and avail the remedy under law. This was the case.
51.
May extension of time for appearance.
Where is the order?
Data.
Where is the order? Which order we are seeking extension? This is which item you are appearing?
51. 51.
51. This is against cognizance order. You are seeking extension. I don't know what is it.
Earlier disposed.
Where is the order? Without preparing, why are you coming? You tell me what is the case?
Order.
What do you want?
Extension of time.
Extension of what time? Which court has given you time? To what? Which is the order where this time was granted to you? Show me that order. This petition is for quashing of cognizance order. You are asking extension of time. Which order you show me at least?
Sir, urgent.
I'll not adjourn it. Now you sit here and read and tell me. I'm not going to adjourn. You don't read and come and read. Sit here. Take the file. If you don't have, give the file. Court file you give. Sit here. And tell me exactly what you want. Yes. Sit here and read. And don't take the court file. Yes. Yes.
So, my lord, against the order of conviction, my lord, I have served a copy on my lord.
Appeal.
Appeal, my lord. On the last
2011.
Yes, my lord. Your lordship had directed on Monday to serve a copy on my learned friend, and I have served on a copy. Official ଦେଇଛୁ 30 ତାରିଖ ଦିନ 29 ତାରିଖ ଦିନ order ହେଇଥିଲା.
So this is for hearing.
This is for hearing, my lord, because the petitioner is on deathbed. I have told that
Yes.
78, near about 78, 79, and the doctor has asked for the bribe, but doctor has acquitted this. He is the attendant because the bribe money.
Yes, he has a personal problem.
I am not standing on the way of my friend also.
Yes, no, because he mother is not well. He told me that. Okay. Next week, when do you want?
Tuesday or Wednesday? Monday.
It's a harsh case because the doctor is acquitted, the attendant is convicted, and he himself is in deathbed.
Yes. A paralysis is
Let us do some justice to him. Okay.
Tuesday or Wednesday?
You tell me Wednesday, Thursday. Okay, Thursday. Thursday. Huh? Get ready, please. Huh?
Obliged. In admission, fresh admission on
No,
that
no,
day also I have
it will come in
requested,
the
but it
admission.
has come in orders again. Fresh admission on. Obliged.
Yes.
Item number 53, my lords.
Hmm.
Please, my lords.
Yes, tell me. Good that he is arguing.
He has prepared, let him.
You should allow him to argue. Yes.
My lords.
Oh, Mr. Marana is not well. You tell me what is the case.
Yes, ma'am.
Let's get it, but since he has prepared, let us understand what he says.
My lords, grateful.
Yes.
Lords, before I just place this matter, my lords, I would just like to bring this to your lordship's kind notice that the accused that I am representing today, my lords, he was a medical officer in a government hospital, my lords, CHC.
Yes.
And pursuant to the conviction, my lords, he was terminated from service. And in the meantime, he has died. So the present appellant is the widow wife of that accused person, my lord, with due permission of this honorable court. My lords, grateful. My lords.
The application has already been moved and it was allowed?
Yes, my lords. The consolidated cost title has also been
394 application.
Yes, my lords.
Yes.
Well, I have just prepared a written note of submission. My lords.
Just give an overall idea because
My
it
lords,
has to be adjourned. I want to take an overall idea what is it.
My lords, grateful, my lords.
Don't refer to the pages. You simply tell what is the case.
what has happened here is, my lords, so the facts of the case in brief is that accused number 3, namely Sudam Hembram, he was participating in an election, a panchayati election, my lords. And for participating in that, there was a prerequisite eligibility criteria. That was that prior to cutoff date, after cutoff date, none of the children of the contestant should have taken birth. That was the criteria. For which reason, my lords, the prosecution allegation is that
beyond 2 children, you are disqualified.
Yes, my lords.
Yes.
For which reason, the prosecution allegation is that this accused number 3, the contestant, my lords, he in connivance with accused number 1, who was the clerk of that CHC, and accused number 2, who is my client, my lords, prepared a birth certificate showing that all the children of this accused number 3 were born prior to the cutoff date. This is, yes, my lord, this is in crux the facts of the case, my lords. My lords, 14 numbers of prosecution witness have been examined, my lords. No witnesses for the defense, my lords. The finding of the learned court below, my lords, revolves around exhibit number 7 to 9, that is the birth register maintained at the CHC, out of which, my lords, after committing manipulation as per prosecution case, exhibit number 15 to my lords 17, 14 to 17, my lords, birth certificates were given in 4 different children named, my lords, of the accused number 3. On the basis of that, the learned court below has come to a finding, my lords. The finding, my lords.
What is the age gap between the last child and the child which was manipulated? What is the age gap it comes?
Well, that will not be relevant, my lords, in this case. But still then, my lords, if your lordship has posed this question to me, I'll answer it, my lords. The age gap is the last child was born in the year 1999. The cutoff date was for the year 1995. And they have shown it as per prosecution case in 1991. That's how, yes, my lords. That's how they have manipulated as per prosecution case, my lords. The findings of the learned court below, my lords, is with respect to the fact that accused number 1, the clerk, was responsible for maintaining the register, my lords.
Yeah.
The depositions of the witness that have been, my lords, dealt with.
Who all are the accused in the entire case?
My lords, these 3 accused, my lords, accused number 3 is the contestant.
And
accused number 1 is the clerk of CHC. And accused number 2 is my client, whom I'm representing, my lords. He was the medical officer, my lords.
What about the appeal of other 2 accused persons?
My lords, it's still pending, my lords.
Whereas
the second sub-item is of accused number 1, my lords. Second sub-item.
That is
TRLA
Bholanath. Yes, ma'am.
298
And what
of
about the other?
2020.
Other expired. For that expired, the convict who has already expired, no 394 application for them?
No, my lords. No, my lords.
Okay, I'll fix it to be since Mr. Maharana is not well.
Yes,
you next week accordingly fix and intimate him. Would be next week. I'll intimate you. Okay.
Grateful, my lords.
Yes. Next.
54.
Contempt. Sir is waiting for which matter? Who's law? 54 was leading. Yes.
My lord, last of is my lord has directed to her personal appearance.
Yes. Therefore, the issue.
And I have also filed the requisites. Not my lord, they have filed a show cause affidavit now, my lord. And I have to gone through that show cause affidavit. And so far as the compliance affidavit.
1 minute.
So
Let me read the last order. This from APS that the aforementioned direction has not been complied. Therefore, issue notice to contempt and public. Yes, direction is compliant.
Yes, they have, yes, they have
Where
complied.
is your affidavit?
For that one, now I am filing because I could not file in digitally. Now it is late, it become late. I have served the copy now only, and I am.
Are you satisfied that?
No, not my sir. Just they have served, my lord. This is a so called affidavit they have filed. Earlier also they have filed the compliance affidavit to misguide this honorable court. And my honorable
Lordship directed to file.
to direct, therefore so directed that last order, my lord. And now they are instead
File
of
the
filing
so-called
the
lordship that
compliance
same is.
In the last order, I frame the contempt notice.
Yes.
Earlier, only the notice was issued, and I framed the contempt notice.
Yes, ma'am.
If you are
not
satisfied, they complied. It's all right.
Just
If they are not complied,
yes,
not complied, my lord.
then I'll proceed with the contempt and.
Well, not
All
complied.
the
my lord.
dues have been
They have
paid.
just filed so called affidavit.
Lordship, we have
Well, I
a
have
clear to
to-
this one.
Well, go through the just.
Sir, you say that you will go through. Pursuant to the order dated 28/6/2024, the contaminants have filed their response. By way of
So open number 2 and 4 is filed.
by
Open
way
number
of
2 and 4.
Sokaz, by way of Sokaz, and a copy of the same is supplied to the petitioner. Release the matter. Go to Vichar.
Well, let it come and.
You will give a date. He'll give a date. Yes. Give a copy. Give a copy.
A copy I have served.
Just now, sir.
I have served copy.
Taken a copy.
Lordship, only I am my prayer is that open number 1, he has been transferred. That only IS Usapadi has been will be.
May I please, your lordship, this is a matter in which two advocates are involved. And the petitioner is an practicing advocate, and opposite party number 2 is also an advocate. While practicing, they came in contact close proximity, and it is alleged that one day the petitioner sexually assaulted. I am not on the merit of the case, but I approve this honorable court. Subsequently, what happened? Both the parties, they settled their dispute, and OP number 2 is not interested to prosecute the case. The reason behind it is that now he is married, having his family, and if this dispute will come to the public domain, then that may ultimately affect his marital life. That's why she come forward and filed an affidavit before this honorable court, that is on dated 14/10/22, that she is not interested to prosecute the case, and the matter has been settled outside.
Where is the affidavit?
Already filed, ma'am.
Joint affidavit. Yes, Mr. Varma.
What happened in this case, my lord? So they have filed a affidavit, my lord, 164 statement and 161, my lord. Very clear case is all made out, my lord. As per the Gansing case, my lord, where the offence is 302, 395, and so
No, it's
also
not
376, my lord.
302.
That cannot be caused, my lord, and both compromise. Then you have to not say.
Yeah. My friend is right so far the dictum of the
My lord.
judicial pronouncement is concerned. But there are cases where the court will take factual aspect into consideration, and
Are you holding any judgment now?
no.
Just exception.
I will distinguish that fact which my friend tried to
The fact
convince.
is that they are lawyers. The fact that the lady is already married somewhere else and settling her life, and all these are mitigating facts for the population.
Exactly.
Giving
On that point, if your
But
lordship
the
want
judgment
any,
which he is citing, it has to be distinguished.
that case is a general promulgation of the judicial pronouncement. Ordinarily, court will not quash the proceedings so far these offences are
You get
concerned.
some judgment where
It is a-
Past cases, even if Pakso case, my lord, in Raut case, my lord, that case they have got married and they get married.
No, that is a different.
But whether that lady will come to the court.
Yes. My
Yes,
friend is
that was-
appearing on behalf of the opposite part number 2.
No.
Special, no?
See, problem is both of them are law.
Advocate. Gone through my lord. They have also filed affidavit stating that the matter has been okay.
So, joint affidavit, where is the joint affidavit? What does, what do they say?
On date 14 May.
But they have filed their joint affidavit, my lord. They have simply stated that which now pending, as per the above.
No fact, nothing. I am married and I am a practical lawyer. Nothing is written. Where from I will get those things?
I think by the time when file my senior not.
You file a better affidavit and. Better.
I am suggesting, yes, what your lordship proposes, I am suggesting my friend to file a detailed affidavit. Why she is not interested to prosecute?
And to maintain.
And what will happen if the case will
harmonious relationship in the bar, and I am already married, raised with a child.
Family life will disturb.
Family life will be disturbed. Something you write so that these are the circumstances, extraordinary circumstances I take into consideration, and then I give it.
My lord, I am suggesting also one thing. Let your lordship pass the order that both the parties will appear in person. Just simply ask them whether they settle or not, without disclosing the fact, coupled with the affidavit will be filed by your.
I am giving you oral this thing, but without recording, because the can't be a party to insist for a settlement. So it should not reflect. And I'm just suggesting that bring here and with a very good drafted affidavit where I can pick up those things, and by an exceptional circumstances I will allow. Distinguishing Yansing and all. Otherwise very difficult.
Exactly.
You do it.
My lord, there is a interim protection super the
interim protection continue. On joint request by the parties, matter is urgent to next week kar diya, interim order to continue. And what you have to do now, you understood, draft the copy and give it to sir. Sir will wait and then file. Don't file it like that. Okay.
Lordship, item 56, Lordship, I am on VC Lordship. 56 also, Lordship, mediation failed to some reason, but I have the information in the meantime, Lordship, the girl, the victim already got married. So, Lordship, can it be adjusted so that it can be.
Let's see, I am for the opposite party. Let's see, last occasion, you Lordship sent it for mediation, but mediation is failure, Lordship. Here the petitioner's prayer for further investigation, for re-investigation, Your Lordship.
No, that's true. I am not on merits. I am not on merits. If you are ready to.
You have challenged, Your Lordship.
Then kindly adjourn to next week. I can.
There is a criminal case against the present petitioner. And by challenging that for a re-investigation, they have come before this Honorable Court. And
no, I had taken 2 grounds that can be judged, that can be argued, Lordship. Lordship can permit me, I can argue.
But is married or you have married, that is the other thing. You are
no, that is the fact. That is fact. That is
criminal case.
Bring
Now
Lordship
you
to
have
attention.
to prove your Lordship.
That says already got married.
Last already Lordship in.
I am not arguing on merit, Lordship.
2024,
Kindly grant me 1 week time so
you
that I can
for
appear in
mediation.
court and I can argue, Lordship.
This is the case where the petitioner was posted.
Lordship. China border, Lordship. China border.
And you produce a marriage certificate on this day.
Lordship.
In the border.
That is his allegation.
You are fighting for the nation, and you are saying that
that is the allegation. And since then he is saying that I am in border in China border. That the plea, Lordship. But in the meantime, the marriage officer and other has also examined by the police, and a charge sheet has submitted, Your Lordship. And the law and court below has rejected his prayer that you can raise the matter at the time of trial also.
No, I have said in para 5 of
Yes,
my order
Lordship.
that I am of the considered view that an application under section 173 bracket 8
Yes,
of
Lordship.
CRP moved by the accused is not maintainable.
Yes, sir. Lordship.
No, I have taken 2 grounds, Lordship.
But that Your Lordship has sent for a mediation, Lordship.
Yes. I have taken 2
failure,
grounds.
Lordship.
One is, Lordship, that is the one part. Another part is, Lordship, that is question of cognizance, defective cognizance order. So Lordship, let me allow to attend the before Lordship in court Lordship, let it be next week or any other day, so that it can be concluded Lordship.
Good week for the
Lordship.
mediation report. In the mediation report has been placed on record. It appears that mediation has failed. Leaves the matter for disposal on merits.
Yes. Yes.
Yes. Next.
Entry matter continue Lordship. Entry matter.
Entry matter continue.
Let's
That's
see.
all, Lordship.
No entry matter are there.
No, only adjournment petition. I will file if there is there. I will
Whatever
file.
arrangements are there, yes.
Lordship, that is there. Lordship. Grateful Lordship.
Yes. What happened 51? Have you read it? Tell me.
Challenging the cognizance order dated 28/2/1992.
Yes.
My lord, in this case, FIR was registered on 1991.
You were asking for extension. What extension?
CRLMC order dated 8/5/2024.
Which page? Page? Have you read it or not?
Sir, order dated 8/5/2024.
8/5/2024. Which page? Where is that? Page number, you tell me the page number. 8/5, okay. Yes. Yes. You want extension of time?
Yes.
Up till
1 month.
1
month.
1
month.
1 month. By order dated 8/5/2024, this court has directed the petitioner to appear or surrender before the court below on or before 30th June 2024 and seek remedy available to him under law. For the reasons stated in the application, he seeks further extension of 1 month to surrender or appear before the court. Accordingly, the application is allowed. Petitioner is directed to appear or surrender before the court below on or before 30th August 2024 and seek remedy available to him under law. It is made clear that no further extension shall be granted to the petitioner. Yes. Next.
97.
May the last occasion Lordship directed my learned friend, senior friend, my lord, to ascertain whether the petitioner are alive or.
Yes. Yes, my lord. I have an instruction, my lord. Petitioner Virupaksha Behera and Jubati Behera have been died since last 5 to 6 years. Others are alive.
Petitioner number 5 and
Virupaksha Behera and Jubati Behera.
8
have been died since last 5 to 6 years.
Pursuant to the order dated 23/7/2024, the IHE Firingia PS had submitted a report whereby he has stated that petitioner number 5, Virupaksha Behera, and petitioner number 8, Juvati Behera, has already expired. The written instruction is taken on record. Taken on record. In view of the aforementioned facts, in view of the same, the present petition, the petition number 5 and 8 stands abated. What about the other?
Others, my lord. The case of the prosecution, that my lord, it is dispute
It is
with
the offense under?
offense under 324, 326 by 149(1).
Sentence?
6 months. 6 months.
Yes.
First time offender, my lord. And dispute, my lord.
I will give you a provision of offences. Why are you trying unnecessarily?
Yes, my lord, that is my.
Why are you?
No, I have not.
Chalo, PO को की छोड़ दो.
Oh, nice.
But always serious.
Huh?
Serious, serious, and every day serious.
I saved your much time, you just see, within 1 minute. Otherwise, you would have argued everything.
I have, my lord, prepared. All.
Your preparation has gone waste.
No, not to wait. Oh, nice.
May I please your lordship, before my learned friend was come all the way from Bhubaneswar, I'm happy to see him in the court. My lord, sir, this is a case, my lord, my learned friend has filed as revision, my lord, challenging an orders by which his discharge application rejected. But in the year 2022, my lords, the another bench of this Honorable Court, my lords, passed an order in 14/7/2022, directing the Vigilance Directorate to file a reports indicating exact completion of the petitioner of the role played by the petitioner. My lords, when this matter, yes, my lord,
Petition for what?
the petition for against rejection of discharge application.
That your lordship directed by 15/7/2024. Your
And
lordship's order 15/7/2024, order number 4. Your lordship directed if affidavit not filed, they have nothing to say. So
In fact, the reports 14/7. The report I am filing, my lords, I have served a copy to my learned friends, my lords.
14/7.
14/7/2022, my lords. By Justice A.K. Mohapatra, my lords.
And my lord said
And
that
report
if by the
indicating the exact role played by the petitioner.
yes.
What are the allegations?
The allegations that he was the part of that committee, my lords, which in a clandestine manners, irregular manners, has allotted swap rooms, my lords, in favor of 49 persons, my lords.
My lord, not a single word there is again. If I admit, if I admit the entire prosecution case in verbatim, the entire document produced by the prosecution, not a single word of allegation exists against me. That is the reason your lordship directed. Now, if this is your lordship they have given today, now if this is whatever everything they have to say, I may be given only 1 day time to go through it. Your lordship may call it only 1 day time. And if they want to file anything else, they let them file, because there must not be piecemeal.
This is what? This is against cognizance order.
No.
Rejection.
I have pleaded
Why this court will get into collecting evidence?
No, my lord. With respect, I absolutely not, my lord. If the entire prosecution case is admitted by me, no charge can be framed against me. If I admit the entire prosecution case.
From the record, you demonstrated whether the case.
Yes, your lordship. Yes, from the record I will show. They are only their evidence. I will not adduce a single document from my side, because I am well aware of the fact that there cannot be a fishing roving inquiry and mini trial cannot be held.
If lordship permits, I agree with you, lords, that he has been provided with this copy, my lord,
Yes,
now
sir.
only at General Lunch hour. I will also come back to
Pursuant to the order dated 14/7/2020.
and your lordship order dated 15/7.
And 15/7/2024.
Report has been filed.
24.
The report indicating the roles.
The report
indicating the role played by the petitioner.
Indicating the role played by the petitioner.
Is filed and the copy is
filed by by Mr. Das.
Copy sought.
Which has been supplied to him by the Superintendent of Police Vigilance Cuttack Division, which is taken on record.
And in the meantime, my lord, sir,
stay is operating.
Your lordship permitted me to seek adjournment in the court below.
That's the problem. Once that kind of order is there, and keep on adjourning.
No, only I have never prayed for time. It is only the learned counsel for the vigilance who has prayed for time.
No, that was delay on one part. Is correct, my lords, with regard to filing the reports.
22
correct,
discharge petitions.
This
This is also, according to me, is not required. But if earlier orders are there,
that's
this is only your lordship.
Record, you see, you have a case, you have a case, you have not. Why?
My lord, with respect, my lord, if I admit all the documents, all the statements examined by them,
the only test.
But that no case is made out.
That is the only test.
Yes, your lord.
We have to see whether the allegations are there or not. If he's not there, he's out. If he's there, he's in.
Yeah, no, in fact, this we get the breathing gap, my lords. I'll also get all the statements of the witness and all this thing.
Don't give much importance to this report.
Monday,
show me from the record if anything is there or not.
The case was last posted on 25th/4/2022 for framing of charge.
Then it
Thereafter
go
that,
on and on. Yes, next.
Monday minutes.
1 week.
The interim order may continue.
There, I'm not saying.
The same arrangement, I think he can manage the matter.
No.
He was presiding
Say
judge.
from
my lord.
20
He knows
this
that.
is being managed, so it will be managed for another one.
Only I may that interim protection may continue.
There, I'm not saying. Yes. 59.
My lord, this case, my lord, pertains to. This case, my lord.
I was seeking time.
My lord, yes. Let's put it some other day, but here the petitioner is the wife, my lord, so was having independent income. Now he has filed his application challenging in a D case rejecting or a discharge application. My lord friend it's requested me also. I don't stand on the order.
1 week after.
You are saying that
12th.
No. 1 week. We'll adjust our. It's very difficult. You choose according to your this thing.
Then-
I have 1,000 and 1,000 cases.
Correct.
How will I adjust my diary?
Yeah, correct.
That's the whole difficulty. Once a date is fixed, if you seek unnecessary adjournment, it is an impact on the board, the entire board. That's the problem. Yes. So unless there is a very pressing need of adjournment, please don't ask for adjournment.
No.
Try and finish it up. Yes.
Item 16.
Item did you pass over?
Pass over at this stage.
One minute. And just he is coming from quarter 17. He is
Huh?
on lag, Mr. Pujari.
It will not reach, sir. I have fixed some matters to be heard.
Within 10 minutes it come.
Next
week also.
Next week.
Next week.
61.
61.
Item number 61. Will ask for your. Will am I audible?
Yes, sir.
Am I audible?
Yes.
Yes. Will ask for your lordship's direction. I have filed today a written note, and my associate has gone with the note. Lordship may see that. The other day I argued that there is observation of this honorable court previously on the points which are now argued before your lordships, and kindly see that note.
Yes.
That note, the judgment which I am referring to, Miller, that is at page 7. It starts from page 7. Kindly see.
7. Okay. Yes.
That this is a long judgment on bail application, rejecting bail application, and dealing with all the points, Miller. And Deepak Gupta is the
What about the first judgment?
first judgment bail rejected. This is the 5th application. This is the 5th
judgment of the Supreme Court 99.
This also went to Supreme Court. I think that is my instruction, and SLP was rejected. Thereafter, he filed another bail application here, and there the Honorable Court passed rejected the bail.
I am asking something else. You have filed this judgment, P. Nalamal versus State.
Yes, that is the first Supreme Court case which that other day read out. I had not given the copy. Therefore, I had promised before lordships to give the Xerox copy.
Okay,
Yes.
you read out that portion right now. Yes.
Yes, that portion mirrored. I'll read from
And
that.
page 7 is the
Yes,
judgment
yes,
of this court.
Yes, it starts from page 7. Kindly turn to Miller page 9. I will just give relevant portions. I will show to your lordship.
Yes.
This is a long judgment. Page 9. His lordship, paragraph 2. Miller, the allegations against the petitioner from the charge sheet is quoted. Lordship may kindly see page 10. Next.
Yes.
Page 10 bottom. Investigation also revealed that Sri Deepak Gupta and other co-accused entered into criminal conspiracy with the public servants of Mining Department, Forest Department, and Revenue Department, and in pursuance of the said conspiracy, they have dishonestly and fraudulently indulged in illegal mining from the reserve forest area and government land much beyond the mining lease area of Sri B.K. Mahanti. My lord, mark this. My learned friend is creating a confusion that B.K. Mahanti is against B.K. Mahanti. Government has, the report is that 300 odd crores is the appropriation. So how 1600 crores is, our case is not that. Our case is he has conducted mining in lapsed area of Jagdish Mishra and from Uliburu Reserve Forest area. Lordship may read further. Sri Deepak Gupta confessed that he has indulged in illegal mining. Lordship may mark this. Mining and has shown the area near the mining lease area of Sri B.K. Mahanti, from where he has extracted the iron ores. The said area has been demarcated during joint physical verification by a team consisting of mining, forest and revenue officials, and by conducting DGPS survey and taking DGPS readings of the demarcated points. The DGPS survey clearly proved that the mining was done outside the leasehold area of Sri B.K. Mahanti, that is, in the reserve forest area and in the lapsed mining area, last mining lease earlier granted to Sri Jagdish Mishra. Kindly mark this. So the contention of my learned friend is completely given a throw by this judgment. Then you will also see the bottom of that page. Sri Deepak Gupta has dishonestly and fraudulently sold the illegally extracted iron ore at a very low price to his group company, Messrs. Deepak Steels Power Limited, where he is also a director, along with Sri Haricharan Gupta is his father. Thereby, Messrs. Deepak Steel and Power Limited became the illegal beneficiary of the stolen iron ore. Well, this is how 411 comes. Stolen iron ore. In the process, Sri Deepak Gupta, Sri Haricharan Gupta and others who accused also evaded a huge amount of criminal taxes to the tune of rupees 44 crores and odd. Then I will skip over. I will not, your lordship may go through this, but I am not taking time because these are all the, then your lordship may now turn to the relevant paragraph, that is at page 15. At page 15. Only relevant I will point out. Below page 15, your lordship may 8 lines from the bottom, the sentence starts, the Learned Council emphasized.
Yes.
Lordship, mark this.
Yes, yes.
The Learned Council emphasized that as per charge sheet, there are 178 witnesses. Here the Learned Council is the petitioner's council.
Yes,
178 witnesses to be examined and 50,000 pages of documents are to be proved, and it is not possible to conclude the trial for years together, even if it is held on day-to-day basis in view of number of counsels engaged by different accused persons who are supposed to cross-examine all those witnesses, that the accused persons would adduce defense evidence, particularly when the learned trial court has not been specifically designated to try this case, and it has got several assignments.
Yes, I
and
got it.
therefore, my lord, your lordship has got. My lord, kindly see the next relevant portions I will point out. My lord, that is page 22, your page 22, your lordship has see. Sorry, page 27.
Yes.
Miller, here, of course, it starts from page 22. It starts from page 22. Here, different citations of the apex court, rulings of the apex court was cited on behalf of the state to say that even if there is delay, the delay may be owing to many reasons, and that can't be a ground to hold that the liberty of the accused is violated, and he must get bail, or he must be released, or charge maybe he may be discharged from the year. That is the finding is. Will kindly see page 22. Page 22.
Yes.
That is the Nimogoda case. Your Lordship must have versus CBI. This is the below the bottom. Economic offences constitute a class apart and need to be visited with different approach in the matter of bail. The economic offences, my Lord, I am relying this. The economic offence having been rooted, deep-rooted conspiracy and involving huge loss of public funds needs to be viewed seriously and considered as grave offences affecting the economy of the country as a whole and thereby posing serious threat to the financial health of the country. Well, this is an economic offense, and my own friend is saying he shall not be tried. Kindly see next page 23. Well, this is an observation from the 87 AR 87 Supreme Court 1321. The Honorable Judge had taken into the mere fact that
I think we need not go into all these things. I understand it, and all the judgments are in the similar line.
yes,
And the allegations are
so
serious.
all these judgments are similar line, and Milord, if your Lordship will see all the judgments, Milord, it comes out that delay is a matter, no doubt, but liberty of the accused on that is never taken away. Accused has to face the consequences. Delay may be due to non-appointment of a judge, due to strike, due to corona pandemic, due to other issues, but that cannot be a ground to hold that the liberty of the accused is violated and he is entitled to a benefit on that. Your Lordship may now see, I'll take to the relevant page 27.
This
My Lord?
after this order, the petitioner went to Supreme Court, and what Supreme Court granted bail.
No. This order was, my instruction is, this order was SLP rejected. Then he filed another bail petition here. It came before the very same judge who passed a long speaking order, rejected the application, but granted bail for 1 month or something like that. Against that, he went to Apex Court. Apex Court said, all right, he has undergone 7 years in the prison. So therefore, let trial go on. Bail that was granted. But the crucial finding in this case, I will show to your Lordships. It is held that the accused have, in this case, the accused himself has caused delay.
According to you, the charges which has been framed against him,
yes,
derive strength from these observations also.
Yes.
Yes, and these observations are judicial observations made in this
right.
case. So,
And Millard here
can't be washed away like this.
Yes, and Millard, the exact finding which I wanted to, Millard, will you Lordships look to page 27?
Yes.
One paragraph of Anthony's case. Page 27. I will not take much time, Millard. I will just now, within 10 minutes, I will complete. Your Lordship. Page 27. Millard, the bottom. At the same time, Lordship, kindly.
One cannot ignore the fact.
Yes, one cannot ignore the fact that it is usually the accused who is interested in delaying the proceedings. As is often pointed out,
But he
delay
doesn't
is
say, he doesn't argue on the ground of delay. He doesn't say
No,
that since it is delayed, you drop the
no.
petition.
He argued on the ground of delay in the process. There are so many witnesses to be examined.
No,
And
delay. I don't think delay can be a ground.
that's what I'm saying. And the finding in this case is the particular finding in
And trial is proceeding, not that trial is stopped. Trial is proceeding.
yes.
That
And
is
the
shown.
exact finding you also may see page 30. Only
Yes.
page, Melody, it starts from, I will take your lordships to the exact finding. That is towards the end.
Yes.
What is lordship's hold? Millard, see page 34. Page 34.
Yes.
The exact finding I am taking to lordships. Page 34.
Yes.
Bottom paragraph 8. No doubt.
No doubt while rejecting the prayer of
Yes,
bail.
while rejecting the prayer for bail of the petitioner in BL number so and so, direction was issued to the Law and Trial Court to take immediate and effective steps for framing of charge and also to take all possible steps to proceed with the trial on day-to-day basis to identify and examine the materials witnesses at the earliest, which would not be possible, and as for the specific order dated so and so passed in the bail application, charge was framed on 5/6/17, our case 17, but the order sheet of the Law and Trial Court produced by the parties during hearing of the bail application goes to show that even after supply of police papers, one after another petitions were filed by the petitioner.
Come to
Means
the last,
the
don't read all these things, come to the last line. Therefore, when
Yes.
the accused persons, including the petitioner, are playing hide and seek with the
hide and
court,
seek with
just
the
to delay
court,
the
just to
progress
delay
of the
the
trial.
yes.
More particularly, the petitioner was keen to see that the trial
That the trial is
not
not progressed for about a year.
Yes.
So
Yes.
so there are already made sufficient findings, and this honorable court has held not once but several times there is sufficient prima facie allegations to proceed against the accused persons. So if there is sufficient prima facie allegations to proceed, but at this stage my humble submission is, can it be said that just paragraph 37.
How many witnesses have already been examined? 55, you said? 53.
No, 55 by before 20th of July. Date was fixed to 20th July. That instruction I have not taken. Might be another 2-3. Another 2-3 must have been.
Total witness 178.
Yes.
Okay.
And this, one finding I want to point out, page only one line, page 37. Page 37.
Yeah.
That is 6-7 lines from the bottom. Is strong.
I have already marked.
Okay, Lordship. I am obliged. Their Lordship say.
I have already marked this red line.
Well, I am greatly obliged.
Already marked, yes.
And that 65 Supreme Court judgment I have given.
Yes, yes.
Along with, yes.
Cited that day the entire text was not there with me.
Yes.
Yes. What do you say?
Lordship, in reply. Lordship, the first contention raised by my learned friend as regards the framing of the charge is that my learned friend argued that once a charge for the offense under section 120B is framed, the person needs to be charged for the substantive offenses for which the co-accused persons are charged. And accordingly, he justified the framing of the charge for the offence under section 13(1)(c)(d) of the Prevention of Corruption Act.
No, he doesn't say that. He says if there are many accused, if one accused has committed a particular offence, and even if the other accused has not committed that particular offence, but under the if 120B is there, it will be treated as if he has also done it.
Yes,
That is what he says.
Yes, I am also on that.
So you have emphasized on 409.
Yes.
You say 409 is not made out against me.
Yes.
I have not done it. He says that since 120B is there, you might not have done 409. Some other accused might have done it. So therefore, it is covered. That's his case.
Lordship.
And he is relying upon those judgments.
No, Lordship, may kindly seek the judgment, the citations which I have filed today, additional citation. One.
Today I do not know what my learned friend has filed.
Code 1762.
Yes.
Lordship.
Yes. Now you gave me the recent one. Don't cite 61 at all. Recent, you have any view?
There are many judgments, but
you know Supreme Court every day there are some.
But why I have cited this one? The reasoning is that this judgment is being quoted in all the subsequent.
Therefore, the last one you show me, the latest one.
But the principle is same. Lordship, let me point out. Lordship,
which judgment has postulated the principle? Show me that.
This one.
Which para?
This one. I am pointing out.
In the 1961, this kind of crime was not there. That time the view was like this.
No, Lordship, the question is when somebody is tried for conspiracy for committing a particular offense, then whether he can be tried for the offenses of the other accused persons. As your Lordship point out that there are many accused persons. And my learned friend cited, Lordship wanted the recent judgment, my learned friend cited P. Nalamal. P. Nalamal was dealt with by this honorable court in the judgment where the wife was, the proceeding against the wife was quashed by this honorable court in a case of disproportionate assets. Therein P. Nalamal was quoted and P. Nalamal was relied on. P. Nalamal, which decision my learned friend quoted, is regarding abatement. And the same principle also applies regarding conspiracy.
Ingredients of 107 and 120B are different.
Different, Lordship. But
you can't draw parallel.
The principle is that conspiracy is a distinct offense by itself.
That's right, you are right.
Yes. And accordingly, this judgment AIR 1961 Supreme Court says that if one is tried for conspiracy, it does not mean that you will be tried for the other offenses too. I am pointing out, Lordship, the relevant para.
Yes. You mark the para and give me.
Yes. I mark the para, write it on the,
at the top and
top of the judgment
and give it and read
it. And I will submit. Now, Lordship, another judgment which I am pointing out, AIR 1991 Supreme Court, the page I will be giving. Lordship, therein what happened, the boss was taken by the accused to a Muslim locality, wherein after parking the bus, the driver got down from the bus and went away.
Sir, all these things in the final stage of the trial, all these things can be gone into.
But
the charge stage, you want me to write a judgment on
Lordship, but
everything? How can it be possible?
principle remains the same. The principle remains the same. Lordship, let me point out another thing,
The
Lordship.
charge says there is volume, just see the volume.
Yes,
Every
recent,
judgment,
Lordship
how
wanted,
much one can
Lordship
think of?
wanted recent judgment.
Yes.
The recent
Yes, so
judgments
what
are
go-
already
go
there, which I have filed, wherein the accused person is tried for the offense under section 120B and 13(1)(e). 120B and 13(1)(e).
Yes.
And therein it relates to charge. It relates to charge, Lordship. Lordship may kindly find page 12, page 12 of the earlier citation which I have given.
264 page. Come to 264 page. I marked it already.
264 of today. I have also given that decision.
Yes.
Yes, Lordship.
That's what
That
you have
also
seen.
relates to the Rajasthan.
Framing of charges only. I've seen it.
Lordship, that also I have filed, and all
I've
these.
seen it. I've seen it.
All these. It points out that if somebody is charged for the offense under 120B, it does not mean that he will be tried for the offense under 13(1)(d) read with 13(2), wherein in this judgment it is pointed out that the person is a private person and cannot be tried for the offense
Where
under
is the ratio?
13(1)(d).
You in this judgment, show me the ratio disjunctive part. Don't tell me the facts.
No,
the facts. I can distinguish the facts.
No.
The moment you say I can distinguish the facts. Show me the ratio disjunctive in
actually.
the entire judgment.
I'm sorry.
All these things are decided on the basis of facts. I can't go into facts.
Lordship, kindly come to page 267.
267. Okay. 267.
Para 6.
Yes. Tell me ratio.
The primary requirement for proving commission of offense under section 13 is that the person being accused has to be a public servant. It is apparent from the record that the petitioner is not a public servant. There is no evidence that they have accepted gratification for themselves as a motive or reward for doing.
So these are facts of that case.
Yeah, fact. Forget Lordship.
Show me the ratio, sir.
The ratio is that the ratio as laid down in.
I am not going to get an inferential ratio from a judgment on facts.
Not inferential ratio.
You tell me the ratio disjunctive of any judgment which you are citing. I will write down I will go by the ratio disjunctive only. I will not go a referential ratio.
Lordship, ratio decidendi is, I have not marked the difficulty is that I will mark and
because you have raised a legal issue.
Yes.
And he has raised a legal issue. You have to answer it.
Ratio decidendi is very explicitly, very cogently, it has been laid down that a person accused of an offense
which
under
paragraph?
section.
Which paragraph of any of the judgment which you have seen?
As I pointed out, I have not marked it.
You just that is assistance you can just render me so that I can find out. Otherwise, I can't read facts of every case to elucidate what is the ratio it could have been.
The ratio decidendi is this, Lordship, that a person who is not a public servant cannot be tried of the offense under the.
I understand what you are proposing. I understand.
Lordship.
Your proposition is completely distinguishable from the proposition he has said.
Here
but you have to. He has substantiated his proposition by judgment. You also substantiate
by judgments.
Show me that. That's
yes.
what I am trying. I am trying to find out where is that whether the Supreme Court or any High Court has really
the exact lines I will submit and 1 page additional note pointing out
that
the ratio decidendi. I undertake to
you write
principle applies. Because
there I understood what your case is. You have a clear-cut case there, no problem. But for the proposition what the senior counsel has said, because of 120B, today I can't distinguish whether you have made this offense or you made that offense. That's what he says. So you are taking the proposition in a different direction altogether. Show me that reason.
That ratio is there.
Then my job is over. Then I understood.
About that, I submitted to
And rest
Lordship,
of the thing I understood.
I will give the exact lining, the page, etc. I will give.
You give that, I understood.
That part gone. Then 409, Lordship, what I was submitting is that while submitting, my learned friend also admitted that there is no entrustment in my favor. He stated that the public servants had dominion over the property. And since the public servants have committed the offense under 409 of the penal code, I also should be tried, which is not
Therefore, you
correct
say,
in view of the.
You say the entrustment, if at all, it is by Mishra, Jagdish Mishra, or that Mohanty.
Lordship.
There is no entrustment from the government.
Then Lordship,
But what his case is, entrustment was made by the government to Mohanty or Mishra, from where you have taken power of attorney.
Government.
So therefore, the 120p is taking.
No, Lordship. He stated that over the land where illegal mining was done, which is outside the leasehold area of BK Mohanty and within the reserve forest and government land, the public servants had dominion. That was what he was submitting. And that area was never entrusted to BK Mohanty at any point of time.
Okay, no problem. Your case is
My case is completely different. Because I stand on the shoe of BK Mohanty, having the power of attorney holder of that person.
Suppose the untrusted area, if you mine, for example, what would be the offense?
Offense is illegal mining. Illegal mining under the MMDR Act.
And there is no criminal.
And
no penal,
379 IPC and 373 it will come for theft if something is taken out. Illegal mining and theft. For illegal mining, they have filed prosecution report before the court of the magistrate as I was submitting. My point is not that, Lordship. My point is that, which I had already submitted, and in reply I am reiterating. My point is that, as I pointed out to Lordship, with the additional documents that I filed, 2 documents, the power of attorney of Jagdish Mishra and the second document.
Yes.
Lordship, may kindly come to the second document. The second document.
You tell me, I understood.
Lordship, just a minute, Lordship. I am showing. I am exactly showing to Lordship. Lordship, may kindly come to page. No. Lordship got it. Lordship may kindly see the page number. This is page number. Last but one page. Last but one page from the top E. Lordship may see present status of the lease. Non-working since 31/10/2009. Then page 9. भूल भटका करके वो कुछ 11 नोट है आने कोई नहीं आओ अच्छी देखिए मैं এটা হলো তোমার ডকুমেন্টস তো এটাই করি দেখা আউট अच्छी আউট দেখে
You get that
at page 8, Lordship, it starts. Page 8 is the letter of the Director of Mines.
what do you want to show? Tell me.
I want to show that not only the pillars are intact, the boundary pillars.
That you have already pointed out.
That I have already pointed out, and they have also pointed out that there was no illegal mining. The mining has been done within that area. When my position, Lordship, may kindly appreciate.
What about the findings recorded by the single judge of this court?
About that,
on facts?
About that, I'm confident.
How will you get over if sometimes extensively arguing at interlocutory stage is so dangerous.
Lordship,
inviting
kindly see page 282 of the today's citations I have filed. This is the order passed by the Honorable Apex Court in the case of Hemant Soren, which is a few days back on 28th of the last month, July, I think the order has been passed. Lordship may kindly come to pass.
There, but there is a persuasive value.
No, persuasive value, that is with regard to if the bail applications, your Lordship will see all the bail applications. The bail
My Lord friend is only repeating.
1 minute, sir. The bail applications have been rejected on the ground consistently from the trial court up to the Supreme Court that it was an economic offense involving huge sum of money.
And all these things
without considering the evidence.
Judgment reserve. You give
the additional note I will give,
please
pointing out
and
the
send them
and that.
And
My,
ratio
trust-
dicendi paragraph if you can culled out from the judgment and you can reproduce it.
just 2 more lines, Lordship. Just 2 more lines, Lordship, may kindly permit me.
No, my
My learned friend stated that
is-
53 witnesses have been examined. In the decision number 2 that I have cited, the Supreme Court decision of the earlier, that is the case of State versus Superintendent of Police through Special CBI.
My Lord, earlier this point I
Arjun
argued.
Bora, 71 witnesses have been examined, and yet the Supreme Court allowed the application for discharge, holding that it was improperly rejected. And accordingly, my case is to be considered. And see, Lordship, if in case the charge under section 409 goes, then the maximum sentence leviable is 7 years. I have already completed more than 7 years. And my learned friend has pointed out that I am required to face trial for another 20 years. At the pace at which the trial is going on, I am required to face trial for another 20 years. And Lordship, I am speaking on the record itself, not outside of it. The petitioner's entire property are attached, including Deepak Steel and Power. Deepak Steel and Power, Lordship, at that time had employed more than 1,000 employees, and all are out of job. Deepak Steel and Power at that time was giving revenue tax to the government to the tune of more than 318 crores per annum. And Lordship may kindly calculate that from 2013 to 2014.
What they say
How
that
much
whatever
loss
you taken also.
how much loss the state has suffered? Is
It is
it in the interest of the
money.
state?
We'll see. I'll see. You just give it.
Yes. Tomorrow I
By
will
the
give.
by the time.
Tomorrow.
By the way, Mr. Panikrai, one question, last question to you.
Yes.
How many years you will take to conclude it?
That how can I, my Lord, say it may be another 1-2 years. And he is already in bail. So therefore he has nothing to complain.
See, bail is one thing. The proceeding and the ordeal of the prolonged trial, as a result of which the business is able to stand still, and all these repercussions are there.
My Lord, my answer to your Lordship is the various proceedings cited in that case which I read out, and the finding of this
I'm just asking you what is the practical approach? Why this is not being concluded for such a long time? Somebody remain in the custody for 7 years.
And
That
another
is
thing,
right.
Lordship.
No, no, your lordship is right. I don't say so. Even your lordship may issue a direction in this proceeding also, but the apex court didn't issue any direction. Apex court only granted him bail.
Bail is
And
something.
but they
I'll just see
they
what
did not
be done in this.
because the problem they knew, because your lordship see, for corona 2.5 years court were suspended almost. It could have been much progressed by now, but because of this pandemic, nobody attended the court. No witness, nobody. Court was suspended.
That 2 years has gone.
2 years has gone out of that. So these
Yes,
things have to be
general
taken
has
into.
gone all over the country. That is not.
Anyway, we'll see. We'll see. You give yes. Next.
Lordship, item number
So the case is
63,
closed,
Lordship.
my lord.
63.
63 was specifically fixed to this
Some
day.
of the day you.
And appeal.
I'll hear it some of the day. It's already 3:30. Let us give priority to some revision. Small matter, old matters. I'll hear it. Let it be there on the board. Let it be there on the board.
It's a Lordship. The difficulty is that there is a humble request, Lordship. The difficulty is that the person will retire very shortly from job.
I'll put it
And
next week sometime, because in any case, Mr. Rizvi was having some personal difficulty also. Let us put it next week, next week, 3 o'clock sometime. Adjust करके रखिए. ठीक है. He will do it.
3 o'clock the coordinate. Kindly
coordinate. She will coordinate.
Lordship, three two times has already been gone.
That's right, but see, in the same time, for your matter, how many hours I have given?
Yes.
About 2 or 2, more than 2 hours I have heard. 2 hours also we have taken out from this heavy schedule. You shortcut, prepare a note, and whenever I'll hear it, I'll not hear more than half an hour. I don't give time
very
more than half an
shortly.
hour.
Not, I will not even take half an hour. Less than that.
See,
Less
by the time you argue, I read it out, half of it. I go in that way.
I will.
Otherwise, it's a never-ending process.
No. I will take less than half an hour.
You get ready
assure.
next week. I'll also read and come, if possible, if I get. Okay. Next.
Item 61 is closed. Only item 61 is closed.
Yes.
Yes.
I reject the judgment. Yes. 62.
62 will be taken about 12 minutes. 12-8. 12-8, my lord. 62.
12-8.
Yes. Awaiting instruction, my lord. Similar matters, your lordship has fixed to 12-8. So on
12,
that
12,
day. Yes.
So weekly. It is done. Supplementary order, weekly. Now where we were? 100? We see 108. Yes. This the prosecution side has to see small matter, we will dispose it up. Unnecessary, these matters are pending from years. What is the offense here? 109. 109? 109 क्या है? Yes, Mr. Raghunath, just see the weekly list. Is there any small matter which we can dispose of? Or previously also any matter is there? Appeal, huh? Revision, just see.
109, my lord. 307, 148, 149. It's a regular again, my lord.
Next item, I'm on 112.
120.
The C.
120.
This is 498, 304B. Convicted to under which provision? This
7 years, right? 304B.
7 years, huh?
My lord.
To all.
My lord.
All of them.
Husband. 170 years. Father-in-law and mother-in-law 62 years.
7 years.
Husband 27 years.
Yes. Next. 13.
118 there with 69 years old person.
This C.
130 307. 2 years.
Convicted.
Pedal 5, pedal 6 injured, pedal 8 is the doctor, man. Corroborated. Forward evidence corroborated by the pedal 6 injured eyewitness and pedal 8 is the doctor, man. 307. 2 years, 2.5 years. Well, 12 better.
Pass out how to.
Are you ready?
No, pass out how sir करवे.
Right.
No, 307. This matter we PW1. What doctor says grievous.
112.
Bleeding injury on the back of injury, head injury.
118.
Bhujali. No, it's Bhujali and head injury. Next, 114. 118. Is there you are there in any matters? You want to argue?
He want to argue some cases.
Which one?
No, not if he
wait, I just.
He's interested in
Yes. Then we'll see. Just see where the 18.
175.
3. None appeared. Give it to him. A point. None appear in this matter. When the matter was taken up on 12/7/2024 and 16/7/2024, none had appeared for the petitioner. And in the last date of hearing, it was made clear that the matter shall not be adjourned, and in the absence of if the petitioner, nobody appears for the petitioner, amicus curiae will be appointed to us.
Yes, Mr.
Court. Since today nobody appears, I request Mr. Mishra, who is present in the court, to assist the court.
SN Mishra 4.
SN Mishra,
4.
4. SN Mishra 4, that's the problem. And Emakishpuri, Raisi is directed to supply a copy of the paperwork and related papers by tomorrow, lease the matter on Monday. Monday? Supplementary level. Tuesday, supplementary level. So you just prepare the and who will finish it up. 126. Wait, you have to handle couple of matters, not one. 126. IIC was directed 126. IIC was directed to bring the well-beings and all. Dharamgarh. अच्छी किसी information.
Status not received. Send my lord that the letter issued on 19/7/2024, my lord.
19.
My lord.
18 was the order. 18 was the order.
Order passed.
Still awaited.
My lord, I waited.
Wait, don't pass any order. Let us see. Wait. In any matter you got any instruction, I'll take it up. Take
One
up.
matter I have got instruction supplementary that I have disposed of today morning, my lord.
Acha.
2% expired.
That one.
You.
That
Other
you.
matters,
Any instruction, just check it up. If you have any instruction, I will take up. You do have any instruction in any matter? Just check it up. If you have any instruction in any matter, we will take it up.
133.
133.
133. 133. It's out there.
84. One of the petitioner was 72 years in the year 2012.
Hello.
R.N. Rao. You have any instruction?
No, madam. Criminal division master, madam, I have not instruction so many cases since advocates are appearing, my lord. Some cases. And
let us go serially only. We reached 118, na? 118. Display board is working.
Yes, sir.
The problem is when the court is free, ready to hear the matter, nobody is there.
All are
In morning, everybody will come. And
impression that is since vigilance matter going on, Mr. Panigra, RV senior advocate, or that is the advocate thought that it will continue. Or that is the one they say.
Find out and you find out in all the matters and the local police, whoever is the IIC, give direction to them. IIC is also directed to locate the take instruction regarding well-being and all, and prepare the order, give a copy to Mr. Ravra, and you will send it.
Matter. It will be better.
By tomorrow you do it, and today's date you do it, and prepare the proceeding and give a copy to him so that.
Where one of the persons are elder persons.
That's what that's what. If 75, 80 years old, more than that, and the common order will pass. Common order will pass, then so that something has to come on record, and the petitioners are not coming. Accordingly, we will pass that. That's the best. Then okay.
Pardon my lord, item 45 weekly leaves. Can you take it?
You want to argue?
Yes, ma'am.
You tell me. We have 15 minutes, we can finish it up. 40?
45.
So why are you, I am asking who is there to. Anyway.
101,
Vigilance
109
case.
was.
Are you?
Vigilance matter.
Vigilance council has to be ready, na? You should have made them ready. 45.
Tomorrow maybe we can take it.
45.
Tomorrow at 2 p.m.
Who is appearing? Mr. Das. This matter, 45. Vigilance matter. Mr. Rijvi was appearing last time. Mr. Rijvi. You tell, let it be there on the board. You tell me when, if I'm, after 3 o'clock, if once I am free, then I'll take it up. Tell Mr. Rijvi to be there. Okay.
Got you. जो तेरे हो एजेड पर्सन अଛନ୍ତି